if indulge, I beg to mention item number 10.
Item number?
10, my lord. Voluminous record, my lord, you will not be directed us to go through it. We need some more time. Next week, my next Thursday. Wait, dear Lord. Lordship, I pray for adjournment.
No.
But 13 and
Huh? You are in item number 10?
No.
Who is responding? Okay. It's the learned counsel for the parties. Praise Puran is granted.
Next.
The prayer of the learned counsel for the parties, matter stands adjourned and be listed after 10 days.
Obla. Lordship, I pray for adjournment in regard to item number 13 and 14. Lordship, I engage counsel from Kolkata. Couldn't travel due to their flight cancelled. Kindly fix it.
Learned counsel for the petitioners submit that the arguing counsel is having some personnel could not appear before this court due to person. Accordingly, therefore adjournment stands allowed. And the matter should not be treated as part of anybody. Yes.
Maybe developed item 15. Matter of new development book days to read file. I want to put it on record. File in affidavit. Type
Item
15. Part 5.
order matters.
So regarding appointment selection of the method, the managing the minister.
Uh-huh.
Two more cases are filed. Method.
Wait. For order, Mr. Smith.
Yes.
Yes. Yes. Your judgments. Very good. Okay. Third, hearing concluded, judgment reserved.
What?
Give the judgment. Ulat.
These matters participate at 451 and 457.
I am breathing down.
I have given a written argument.
Where is that?
Last
Central. This is written argument of order petition. Anything from the respondents? This is for petitioner.
May not be mine.
Filed by the petition. Okay. Just a minute. These are the judgment.
With bulky, madam.
Okay, I have got it. Written argument of the, this is also petitioner. Wait, State of Assam versus Ram Shankar Moria.
Yes, that's
So job is up to me now.
not because I will not be going taking a lot through all the phases, madam. Some portions of this written argument will be relevant.
Okay.
Relying on these, madam, I will make my.
Okay.
My lord, before that, madam, just to refresh, madam, the division bench order.
Here what I can recall is, if we have a two ways to interpret the division bench.
Yeah.
If this is that, then that will also be that. And that is that, this will be.
Either way.
Either way, it should be either way.
We
Now,
will-
what is the, suppose we come to a conclusion that this is ambiguous. Then what is the option left with a single? Address us on that.
My lord, my respectful submission would be, my lord, to follow the division bench judgment. And if there is some element of ambiguity, my lord, refer it to a larger bench or place it before honorable chief justice. Because that is the propriety of judicial propriety. Even in case of coordinate bench also, my lord, it's a division bench judgment.
No, it's, we
In
understand.
respect of
We
coordinate bench
understand.
also, my lord, the proper course is to, my lord, place it before a honorable chief justice to consider.
Because suppose we agree with the division bench view, or it is a binding upon us. But second part, how will you reconcile with the first part?
True, my lord. In fact, my
That
lord,
is where we are finding a difficult.
in fact,
Otherwise, suppose we agree with the division bench judgment, or there is no question of agreement or non-agreement. It is a binding precedent.
yes, rightly or wrongly, my lord, division bench
Bench has decided.
Yes.
So this is binding.
Yes.
But the principle, what is binding upon us? Binding upon us is the ratio.
ratio.
So ratio so far relating to one section and the ratio laid down to the other section and contradictory.
Contrary.
Both cannot be reconciled.
True.
So if cannot be reconciled, what is the option left to a single judge?
To place before a division bench. Not to, my lord, deviate from the
No, we are not saying about deviation.
disagreement is different thing, my lord. But
Yes,
seeing a
we
different order is
understand.
different thing.
Because judicial discipline requires.
Disagreement is permissible, my lord.
Yes.
My lord may disagree.
In fact, in one of your cases, I
True, that forest matter. my lord.
Forest matter.
royalty.
In fact, I wrote a paragraph on that.
Yes.
The same will be applicable here.
There also, my lord, I lost this case because there was a division bench
Yes.
judgment, which my lord agreed.
Yes.
So I took your lordship to other judgment.
Mm.
So in similar situation, my lord, similar ratio
Yes,
is
yes.
applied here, my lord.
But here a further difficulty is there. In that case, you cannot say that we express the view that two judgments in a different context, facts were different. We took a view. But here in the same judgment, subject to what
There is
others say,
separate law for 451 and 457. sir.
50.
True.
How
To
will
that
we-
extent, my lord, in fact, though, my lord, we were happy with the division bench order because in practice, my lord, state didn't lose many, my lord. But my argument before the division bench was also, my lord, not to grant custody in respect of 451 and 457 during investigation. That was my argument, my lord.
No, that we understand.
So, as my lord has rightly said, my lord, either custody can be granted in both or cannot be granted in
Contain
both.
both.
So my argument would be cannot be granted in both. So disagreement of my lord.
No, that would have been, I could have answered in a single bench when it is before only the single bench without the division bench judgment.
Exactly.
But here there is a division bench judgment where subject to what Mr.
In-
Ahmed also
in-
says, there are interpretation is contradictory.
True.
Same ratio is not applied to both the sections.
True.
Two different
So-
ratios are applied.
So my submission would be, my lord, as prima facie, my lord is in agreement that custody can be granted in during both in for
Yes.
But there is a possibility of coming to a conclusion cannot be granted. So my lord may have disagreement in both the accounts that it may not be or it may be. So in that situation, my lord, to come to a conclusion whether disagreement is one-sided or in the other side, my lord may have some deliberations in this matter, or my lord may refer it to the division bench.
So we want you to address on that point.
Yes.
Both, Mr. Ahmed, you too.
For that, my lord,
But I do not think you have also any dispute as regards the ratio. Is not it? You will say that second part of the ratio is the proper ratio in view of the earlier judgment of the Supreme Court. Okay? Your argument will be, therefore, if the single bench agrees with the subsequent part, as already there is a Supreme Court judgment, so this court can ignore the other part of the division bench. That will be your argument. His argument will be the division bench, after taking note of the Supreme Court judgment, passed the judgment, interpreted it. Now this single bench cannot sit over that interpretation. That will be your argument. Because that was placed before the division bench. Division bench considered and discussed, and on that basis that has been passed. However, so far relating to the second part, in fact, there is no specific discussion. Why not? Why a different view has been taken?
apparently, my lord, 457, my lord, the ratio of the honorable division is primarily, my lord, based on the judgment of this Ram Prakash Sharma.
Hmm.
But Ram Prakash Sharma, there was no issue frame on that. It was purely on fact,
Okay, let us go to first division bench.
first division bench.
Let us refresh it because in the meantime, that will not conclude. Your voice is not ready for a long week.
Even, my lord, I had also a surgery. So I am also feeling some difficulty in, my lord, making it long.
So what? In a better way, in a better day.
Maybe not. In fact, P.K. Roy, learned advocate, my lord, he has some maybe request to him. We had a discussion yesterday because since it is ordered for quite a long time, my lord, we didn't want to take any action. I will fix it on next Thursday, man.
Next
Thursday,
Thursday.
my lord,
Not possible.
15.
So many methods we are trying to dispose it of now.
12th and 13th, my lord, have personal difficulty.
Mhm.
Rest, any other day.
28. Today is 28, not 20. At least I need 3-4 days to dictate the judgment also.
My endeavor is to, my lord, take your lordship to the disagreement
Hmm.
regarding it cannot be granted.
Okay,
I
will-
may fail, my lord, but I will persist.
you will do the other part. That's all. We have
I may
we
fail, but
understood the division bench.
that's the beauty of
So you will say that division bench finding in the second part is actually the correct law. Therefore,
But only the sections will be
different. And he will say that division bench decision so far relating the first part is the correct law. Isn't it?
because my lord will kindly appreciate one thing. Sundar Bhai Ambalal
Hmm.
took note of a judgment that was passed in the context of earlier CPC of 1898.
Hmm.
And in that case, my lord, police had no power to grant custody and magistrate had power to grant custody at any stage under the earlier code. That was not taken note of, my.
Now we are exercising all this. What the new thing says? New act.
New act is yet to be implemented.
No, suppose we take a decision. What is the new act says?
Then press judgments, my lord, press issues will be raised because our new act is date of appointment is not yet fixed.
Not yet fixed.
It is
Now
not
they
in
are
force.
training the police officers.
So we
What
are
is
all-
the provision there? Are you aware?
No, I have not checked. I will check. I
Check
will
that.
definitely I will check. Yeah, that will be interesting.
Check that.
That will be interesting.
What is the view of parliament in this regard? Let us interpret in that way before coming into.
1973 CRPC, my lord, the law commission report was accepted in toto, my lord. Law commission suggested that what arguments I'm making, that was the suggestion of law commission. That custody at the stage of investigation by police and at the stage of inquiry and trial by.
So therefore, we want to know the view of parliament because there is a huge change of situation.
True, man.
Every now and then, every vehicle are being seized, whether necessary, not necessary. You cannot, no, we cannot go to the factual parts while determining law.
Well, difficulty arises because under the CRPC, it is presumed that normally investigation should be concluded in 24 hours.
Therefore,
That is the rarest thing I have seen, concluding investigation in 24 hours. That's why it is practically difficult.
that is a practical difficulty. Therefore, if there is practical difficulty, how court will
Then
intervene?
482, my lord.
Huh?
482, that's the inherent power of the lordship.
It's a
Not 450 or 457. That's why I'm expecting.
480.
482 by this now.
You want to burden us more.
That
For-
is, my
for-
lords are already burdened by.
That's why for small matters. Anyway, we'll see the practicality. Yes, Mr. Ahmed Goswami, let us also understand what is the parliament view
The present.
in the present context because law they are changing. They
It's
have changed it because
Very
of change of time. In his wisdom, they have changed it.
Yes.
We do not know whether this will be challenged, not
We'll
challenged.
check.
That is a
That will be
different
very
issue. But let us
relevant.
just have the view. What is the view of parliament in the shape of the new act,
That will be very relevant in the present context
present context?
with the change of time. True.
Hard at some point. Place this matter for further hearing on
20,
20
20, my lord. Some different. 22nd, my lord.
22nd.
20,
March,
27.
no, February.
February, 27
February.
February.
Too many
20
methods are there.
27th of February.
27th? 27th of February. Ahmed,
Both by my both by your obtaining code. My can operate that.
Definitely, I can take somebody.
I can
we're not passing any order.
I will take care of it.
nearly with the 290 of
Item 7.
Mr. Goswami, we'll finish on the next day.
May I please it lordship?
In fact, I was thinking of releasing today, but topic is interesting.
Interested so much of time.
Yes.
Lots of time, sir.
Yes.
May it please, my lord?
Yes.
We have received our instructions yesterday, my lord.
Hmm.
Our affidavit is ready and we have sent it to signing, my lord. 1 day time may be granted. Only 1 day, my lord.
There is a judicial order. What to do?
My lord, pursuant to that order, my lord, we are trying to, my lord, yesterday.
When are you filing?
My lord, our affidavit is ready, my lord. Just for vetting, my lord, we have sent.
Oh, vetting, they will vetting. No, if you say that we are filing it tomorrow, we can condone.
No, just I'm praying for this.
Order was passed on 9/1 and it says that respondents are given 2 weeks time, a last chance to file the return. And the event returns are not filed within the period of 2 weeks from today, that is from 19/1. The right to file return would be closed. Now what to do with this judicial order? There is a judicial order. You are aware of that.
My lord, today they are signing, my lord.
What is this issue?
My lord, it's a departmental proceeding issue.
Departmental proceeding. Okay, when can you file?
Tomorrow, my lord.
Okay. Learned counsel for the respondent submits that affidavit is ready and it's being filed by tomorrow. In view of such submission, matter states adjourned and be listed tomorrow, no, not tomorrow, keep it on Monday. Monday possible?
Highly obliged.
Hmm.
Can it be taken?
Why? Affidavit file?
Yes, also file it, but it
Uh-huh.
is not.
Not in court record. Okay, it is submitted that affidavit has been filed by the, but nobody is here. Affidavit file.
Yes, sir.
Followed your lot to the 2042 senior UDA were selected. That your lot you will find it at page.
Okay,
Advertising.
call somebody. We are waiting for some just intimate the BTC.
Fine.
Okay. Huh. That is basic training and
Yes.
not training.
Yes.
Okay. Just remind us what?
Actually, this case is case when he was in basic training, my lord.
He got injured.
Injured, my lord. And
He
thereafter
injured,
he-
so he was not fit to be in the
Yes, my
service.
lord, yes.
So you are asked to go.
Medical board, my lord, thereafter, my lord, he was terminated. my lord.
Where is the medical board's finding? So you just as a general thing,
Yes.
you must tell me. I'm asking. If you go, where is that medical?
Yes, my lord, it is page 34, my lord,
34. no?
34.
Just for understanding, not for this case only. Okay.
I'll explain, my lord, if necessary. here.
Okay. 34.
34.
No, I want a scheme.
Scheme, my lord, this, my lord, first, my lord, there is medical board, my lord, and thereafter he was terminated. Termination was challenged, my lord. But this
So we know that
it was-
again remanded
it was
back.
not interfered, my lord.
Ah.
Thereafter direction was there, my lord. And direction, my lord, for DRP, my lord, to examine the matter, my lord, NTR matter, my lord. So DRP was rejected, my lord. He is not fit for.
No,
the-
we know everything. We want to
Yes.
understand the scheme.
Scheme is, my lord, is page 49.
Now, here's question is limited.
Yes.
Whether under the scheme he ought to have been granted or not.
Yes, ma'am. Yes.
That is the
Yes,
because you have a policy.
Yes.
We cannot say give him beyond
Yes,
policy.
Yes, ma'am.
We cannot say.
The-
So
our-
if that is your policy, you will as per policy he is entitled, he will give,
Yes, ma'am.
give. If it is not, he will not give.
Yes.
Suppose as per policy he is not entitled.
Yes.
He will have his other right to file civil suit or
Yes.
whatsoever for compensation. That is a different issue.
Yes.
Here our limited exercise is whether under the scheme he is entitled or not. Your whole argument on the last occasion was that the scheme is not applicable to those persons who are in primary training or some
Basic
basic training. But this scheme is meant for those persons who has completed a basic training and who has already in service.
Yes.
This is your argument.
Yes.
We want to know from where you have advanced this argument.
Yes.
Now, therefore, let us see the scheme.
Yes.
Scheme is meant for whom?
Yes.
Okay, where is that scheme?
This page 49.
Okay. So we must have a satisfaction
Yes,
that this
yes.
scheme is not made page 49,
Yes.
not meant for him.
Yes.
Now let us read what is this.
I'm reading.
Hmm.
Standing order on number 4 of 2011. Rehabilitation, subject rehabilitation of force personnel. In suppression of earlier order and instruction, including standing order 7 of 99 on subject of following orders are laid down for rehabilitation of disabled persons. The 2. Department has 3 categories of disabled persons. A, who are disabled due to injuries sustained in action against terrorists through slash anti-social element, insurgents slash nationalists while maintaining law and order, internal security, and undergoing training or any other bona fide duty.
Okay, so now here issue is this undergoing training
Yes, ma'am.
shall mean not a basic training.
Yes, ma'am.
Tell us from where you are getting.
Yes, madam. Lordship also for a moment may period the another this the page minus 57 minutes. 57 relevant person is page 58 minutes. Those who are entitled they are given minutes. And they are as per this minus sending order. After 58 minutes, after critical examination of the person and assessment of these and
57.
58 minutes. These are the my lord, as per this standing order, my lord. These are the post, my lord, for whom this applicable.
Yes, 58. What?
After critical examination of the person and assessment of his and her suitability for job, DRP will recommend it any of the tasks for him or her as specified below. My lord, this board will recommend it. This board will recommend it.
That we know. That is the second part.
Yes. And
First part,
yes.
if you can satisfy that he is not entitled,
Yes, my lord.
why should you go to the second part?
Yes, my lord. And these are the my lord. It is written, my lord. Your lordship, these are only for the person, my lord, is other rank.
Other
Where
rank
do you get that?
58, my lord. This itself. Other rank A, light duty for other rank. And thereafter, my lord, is my lord 61 light duty for subordinate officer SO. And thereafter, my lord, light duties for officer. Page 62. These posts are called this other rank A, light duty, and light duty for subordinate officers.
Now 7 is for whom? After critical illness, the person.
After recommendation, my lord, for light duty, other rank. Over light
No, no,
duty.
other we understand.
Yes,
If there are other ranks, who are the other?
yes, my lord. This constable DD included.
Where do we get that? Your Mr. Medhi's submission will not accept.
Yes, my
You'll have to show it from the record.
lord, I'm
You are saying others. We say others. They are others. Who are the other
my
part
lord,
of
here,
this?
Here, my lord, is RT DD, my lord. There's two RT recruit training. Recruit training is general duty.
Where do we get that?
Yes, my lord, this in page 34 of the medical protocol speak in all pages it is there, my lord. On consequent of the above order, board assemble so and so Mustaq Ahmed RTGD Mustaq Ahmed. He is my lord the RTGD. When his training is completed, my lord, he will be constable GD. The constable GD is other rank, and his recruit training. Recruit training is during the after confirmation he will be my lord the constable training, constable general duty. Yeah, as he is a recruit training, my lord, this so far, my lord, I have
So you want to say that a person who is under training, during training made disabled, throw him to the street.
my lord,
This is the principle of force. You want to interpret this code to interpret a disability in that way.
my lord, is
No, we'll interpret that. That this is the policy of the government of India, that a person during training
my lord,
got
what-
disabled
what-
should be thrown out without any benefit.
my lord,
If this is-
benefit is different. But so far, this standing order
Hmm.
attract.
Therefore,
they are, whether
Mr.
they are-
Mahdi, listen to me.
Yes.
Show us from your scheme that this undergoing training shall necessarily exclude training, basic training.
My lord, is their rules, my lord, rules speaks, my lord, 26 training. Here, my lord. Here, standard training. Standard training, Deputy Inspector General shall issue a manual prescribed the standard of training. Training shall include following subject. Those are basic training. They are there.
No, no, I understand.
Yes. And
What is basic training we need not
no,
know.
no,
We
no,
understand.
and undergo.
We understand when a person is recruited, he is sent for a training. He will have to pass the training to be confirmed or to enter into a service. We understand that.
Yes.
Now, there is a scheme which scheme says if a person gets injury, disability during training, there is a scheme for him.
Yes.
Okay?
Yes.
This person was got disabled during basic training. Okay. So you want to say, since it is a basic training, this scheme is not applicable to him.
Yes.
Now, show us from anything that this undergoing training excludes basic training.
Well, the training is defined, my lord. Training
No, training is different, but
Tra-
where is it mentioned
the training
that it is basic training will be excluded? Is there any exclusion?
No, my lord,
What is the definition of training?
I'm
Tell us the definition of
yes,
training.
ma'am.
This is one aspect.
Yes, ma'am.
And second aspect, you will have to answer. This is not your ground to reject him.
Here, my lord, the board is not made party, my lord. It is consists of two doctors, my lord. In it,
We accept board's decision.
board decision says that he's not, they not recommended his name, my lord.
Accepted.
Then,
Accepted that.
so, my
But
lord,
it is not your decision that his case was rejected for the reason that he was only in basic training. That is not the reason.
Yeah, this I'm reading.
Yes,
I'm
that is
reading-
not your reason.
I'm reading this. I have annexed and I file an additional letter.
No, that will go to the second part.
Yes, I
First, you satisfy because that is not your reason.
just a minute. My lord. I will file an additional appeal as per direction of honorable court, my lord.
Hmm.
Is the we have enclosed, my lord, is recommendation of the court, my lord. Page 149, my lord.
Hmm.
150 is the recommendation, my lord.
Hmm.
Number so and so RT GT Mustaq Ahmed has not completed his basic training. At present, having attained injury both knees. He
Who will handle this? Who will handle at a later stage?
Well, these are the because of non-recommendation from for court, my lord.
Okay, you first satisfy us that this necessarily, though there is no clarification, it will not it is necessarily mean or not, it will not include a basic training. Tell us, what do you mean by training? Any definition of the training?
Standard training is there is training, my lord, standard training.
Where is that?
Chapter 5, page 24.
Page 24, chapter 5, section
Chapter
Central Reserve Police Force.
Yes, ma'am.
Rules or act?
This rules.
Rules.
Page 20.
1955.
Yes, ma'am. It is my
Rule
rule 26.
26. Okay.
B, my lord, B, my lord, training shall be included the following subject, my lord. The correct wearing of uniform, cloth, and so.
Okay, where is the basic training?
Yes, madam. This standard training is the initial training. The initial training is the basic training. There is no such specifically mentioned the basic training, my lord, but it is initial training is the basic training.
And what are the other trainings
Yes,
beyond
and-
basic
and
training?
thereafter, my lord, C, my lord, commandant may depute any a member of a force to undergo a course of training or instruction having bearing on the central reserve force work conducted by central government, so and so, so and so, so and so. Thereafter, my lord, commandant may for this special, my lord, this the training, my lord, of special course. This is the called the undergo training.
Where is his appointment?
Appointment, my lord, page, my lord. Appointment is, my lord, is page 17, my lord.
What is general duty?
General duty means, my lord, is those who are, my lord, is
No,
are-
we do not want your definition. We want anything defined in anywhere. What is general duty?
make
Yes.
Duty deal with all कुछ जैसे specialized duty जैसे ministerial category वो वही काम but DD duty में सर law and order maintain sir
No,
there is
that we understand. Anywhere, yes, GD has been defined somewhere
Sir.
that this is in general duty should include this or not.
एस्टेब्लिशमेंट मैनुअल में हमारे हर कैडर की अलग अलग ड्यूटी डिफाइन की हुई है सर
हम्म।
और जो ट्रेनिंग के रिगार्डिंग सर जो सर
हम्म। Just a minute. Just a minute, huh? Yes, बोलिए. Yes. Tell us.
My lord, this so but this as per manual, my lord, this like my lord, so
Mm,
my preference is
Now, first let us
Yes.
understand what is a general duty. It
general
is having a relevance.
yes, general duty means the law and order duty, my lord, especially my lord, those who are my lord deployed in law and order.
Law and order or ministerial?
Not ministerial. Ministerial is just separate, my lord,
Separate.
separate. And so some of the technical, my lord,
And what are the other duties?
technical duties, my lord, there's MT duties, they are motor related duties. There's so many duties, my lord.
General duty means that this with gun and all.
Yes, my lord.
Okay.
Only there's some regarding law and duty, my lord, when they're deploying, my lord.
Okay. Where do we get that? That is the manual.
It is there, my lord. I'll
Just mark it. Mark it.
There is establishment manual, my lord, it is there. I'll
Okay. Okay. We'll just, we want to see.
Yes.
We are a state. We are a country governed by rule of law.
yes,
Is not it? You are a state. Union of India. A person got injured during a training. Okay, he becomes admittedly disabled. There are many schemes for those persons who gets injury or becomes disabled, who are confirmed their disability pensions. Many other pensions and all are there because they have rendered service during. Even court has went into that extent that nowadays law is that if a person is not ill or not diseased at the entry point, at the entry point of service, and he acquires a disease during the course of his employment, even it is presumed that he has acquired for the job. This is the law, isn't it? You may say, may not say, even psychological disorders, courts are holding, Supreme Court is saying that yes, there is a presumption. The other side is to rebut. So in that context, can there be a policy or will a court interpret a policy saying that, okay, you are for training, you got injury, you got disabled, lie down in your bed, we have no response. Our hands are off. Think of it. Kindly come to his appointment.
Yes.
Page 70.
Yes, 70.
Okay.
Yes. Yes, my lord, specifically, I'm
You will rely on clause G.
clause E.
Clause E. After your pension, you seek resignation, discharge under rule saying you shall be required to refund the government a sum of equal 3 months' pay. This is not a case.
My lord, so far, rule 16, my lord, the period of service.
No, we'll go to that later
Yes.
on. We'll come to that. We'll
Because
go
if-
deep
if-
into
if-
this.
If it is not confirmed, he may be discharged. If it is
He may be discharged. There is no problem. A person is supposed,
I understand.
Uh,
But here, my lord,
if he cannot hold the gun, you can discharge. You can say that no, you failed in the training. You go home. That is one aspect. Other aspect is that a man becomes disabled during training.
Yes.
Two different aspects. Now, will the door be closed for him? Is it your policy? If you have taken a policy,
my lord,
then it's well and good.
my lord, so far, rehabilitation
Let
is
us
so-
complete. If you have taken a policy, if policy is not under challenge, we may wash off our hands. That is fine. But your policy says training. Okay?
is undergo training. Training.
It says training.
Undergo training.
During training. Undergoing training.
Yes.
Okay? So during training, you want to interpret this code to mean training in exclusion of basic training. Okay?
Yes.
So to court to uphold your contention, it will require something. Only saying by Mr. S.K. Medhi or you are Mr. Rakesh will not do.
Yes.
We need substantial material to satisfy that training will necessarily mean training after confirmation, not a basic training. Now come to his appointment. page 19, clause 8.
Department has no.
Department has no liability in case of any injury accident during journey. Then why have you not included the training? What debarred you? How will you interpret?
My lord, what lordship is my query is because our hand is tied, my lord, because
No, Mr. Mehdi, don't say hand is tied.
so because this my
This
lord,
is not a question of typing of anybody's hand.
Because-
We will do what law permits to do.
Yes,
We cannot say that, no, though
but-
it is you have clarified that this is a basic training, but will not accept that. We cannot do that.
but the standard orders, code of relevance speaks, my lord, I'm reading, my lord, because my lord, this one is the last, my lord, undergraduate training, my lord, and any other bona fide duty. Last, if it is
Undergraduate.
suppose the basic is the
That is
training,
why I'm asking. This undergoing training according to E in exclusion of basic training.
yes, my lord, this, my lord, this 26C, my lord,
Hmm.
26C, I'm reading, my lord.
It says standard training.
Thereafter, my lord, it's where commandant may deputy any.
Understand? No problem on this.
When-
Parts is
when
just
This when he is deputy tenant, it is undergo training. The training is thereafter undergo training. So lordship will
what do you mean English meaning of undergo?
when he was the,
What is the meaning of
there is
so stand
there is
and
as per-
one
as-
person will not undergo standard training?
as per
No, Mr. Mehdi, tell us. So a person who will have a training under clause 26B will not undergo a training. This
Well,
is not an undergoing training.
no, my lord,
Then what?
my lord, that is my lord, you lordship the correct wording. Correct wording.
So
of the
suppose,
clause, my lord,
suppose,
these are the basic, my lord.
suppose,
These are the basic,
suppose
my
Mr. Rakesh is trained how to wear a t-shirt, how to wear band a necktie, how to wear a dress and shoe. He is being trained. So are he not undergoing training?
My lord, this is the basic initial.
Understand?
So
You are saying undergoing.
Yes,
Is he not undergoing
yes,
training?
my lord, undergoing when he is my lord, deputed to some other course, my lord, it is there, my lord. There's defined one basic training course, promotion cadres, my lord, and the instructional cadres, in-service training course, specialist course. When my lord, after completion confirmation of the service, my lord, the other training is there. So for my humble submission before the honorable court, Lord, you will consider, my lord, this he was in service. He made this he whether and this my lord this standard order not attract the his case, my lord, because it is this order itself speaks, my lord, after recommendation is required. Recommendation from the DRP. DRP rejected, my lord. That was not under challenge, my lord. Because on last occasion, before this, initially if it is filed to bring the recommendation of the DRP, my lord. DRP is speaks, my lord, he is not recommended because of this. So they were not party respondent before this honorable court.
Who are DRB?
Yes,
It's
my lord.
internal committee,
My lord,
is not it?
yes, my lord, they are considered two doctors.
Sir, maybe don't go for these technicalities. Every day we'll dismiss your petition on technicalities. If you argue this, who is DRB? DRB is an internal committee.
My
We'll know the employer.
my lord, direct.
How the employer can suppose the DRB has committed mistake. We'll hold up the employer.
My lord, direction this honorable court was to send it for a DRB, my lord.
Hmm.
So after DRB considering, my lord, I'm directed to appointment. Here, my lord, DRB has considered, my lord, DRB, my lord, not recommended, my lord. This case 80 of this order of this honorable court, my lord.
Hmm.
May I read, my lord?
Who are these DRB members?
DRB members, as per this standing order, my lord, DRB is considered.
Yes, what you say on that?
DRB is there, my lord, as per.
They say that you have not challenged the DRP decision. Huh? Your seniors are out of station, you ought to have. Who is your senior?
He's on leave, my lord. So
Mr. Mozumdar, come forward.
I'm reading page 85.
Assist us. Day after tomorrow.
Yeah, yeah.
Assist us. See, here, basic thing is a person is a prima facie, basic view. We may change our views also. Subject to what say. This is just we have touched the brief. This is our initial. He was in training, admittedly. He got injury. So he was not fit. Training was not complete. He was not fit. So he said, you are terminated. He comes before this court. Then during course of hearing, it is seen that there are some schemes for rehabilitation. Now court says, okay, termination was not interfered, but okay, since he is not fit, how can we court direct that take him? We cannot. So court says, go to the DRB, they will consider and do the needful. Now, if you go by the DRB's report, they are more or less subject to what Mr. Mehdi and Mr. Rakesh says. Where is the earlier order? Rejection.
Rejection order, my lord, the DRB rejection.
That he is this, he is that we have read on last occasion.
Is my lord, the additional affidavit.
Additionally.
It is not.
Now his case was rejected.
Case one.
Now, if you go by the DRB's decision, everything is fine. But problem is that he is not able to do any strenuous activities like PT and parade. Okay, long running, jumping, lifting, weight, prolonged standing. He is not to fit combat duties in CRPF. Admittedly, now you come to the rehabilitation scheme.
Yes.
Where is?
Start page 49, my lord.
Page 49. Now, see, this is their ground. That he is not fit because of this. He cannot run, he cannot do PT, weight, and everything. Now come to page 49. If you come to page 49, you see
Wait.
First paragraph 4 you read.
Undergoing training.
No, not undergoing training, before that.
Those who are disabled due to
No.
Therefore, page 50. No, first is clause A.
Yes.
Those
who are disabled due to injury sustained in action against terrorists
slash
Undergoing
undergoing training
training.
or any other bona fide training. First contention is that this undergoing training will necessarily mean training after confirmation. Okay? Just listen to it. Now come to page 50.
3 also here.
Huh?
Before paragraph 40, my lord. Page 50, my lord. Department should make all efforts to take care of its disabled person without
So if you
compromising,
see the scheme.
compromising with the overall efficiency of
Now
combat.
kindly come to duty B. Those who are disabled due to sickness / accident. Okay? Those who are disabled due to psychiatric disease. All are included. Department should make all efforts to take care of his disabled person without compromising with overall efficiency of the combat force. Okay? So he cannot go to the combat force, that is for sure. Now come to 4. You just keep the other lines. After the sick, have you got it?
after the
Sick / injured person.
received
Receive full medical treatment. And the medical officer in charge of the opinion that there is no sign indication of improvement and that individual is not fit to normal active duty. So how can they insist that he should have a combat power? The basic condition is that he should satisfaction that he cannot do normal duty. The case of the individual should be referred to Departmental Rehabilitation Board. So basic criteria is that he is unable to do his basic duties. Now come to the what can be given. paragraph 7 and 8. See, page 52. Okay, page 1, page A, page 51. A, dark office runner. Okay, suppose he cannot do it. B, telephone operator. He will sit and receive the telephone. Attendance in restroom, welfare center, school bus. Salesperson is canteen, cooperative, floor mill, RTO at railway station, office copywriter, mass constable, serviceman, any other specific job considered suitable for time being. Now they insist that he should have every capacity to combat, to run, to do everything.
My lord, their problem, my lord, is
No problem. There are further problem. There are further problem. Okay. So this is their scheme. Their first ground of rejection is that he is not fit, he cannot run, he cannot take weight, this and that. But they are not understanding that he can even be appointed as a telephone operator. Now that question, Medi says no. While holding telephone, there may be attack.
no.
So he will have to have his gun.
That is normal.
See, now they are coming to the next question that it is not even a training. Training, they are trying to distinguish. Now here training is clear. Standard training, 2 parts are there. So this has not excluded. And if you go to the appointment order, they have
Journey.
excluded some injury
During journey.
by specific during journey. And it's a logic that a person gets disabled during training. Will you throw it out? You are an instrumentality of state. So this is the idea and in the mind of this court. This is for both of you also. Come back and address on the next.
My lord,
We are not taking any decision. We are open to ideas. And Mr. Mehdi becomes so excited.
no, I'm not accepting.
Mr. Mehdi
Not accepting.
Mr. Mehdi is very excited, and Mr. Mehdi, if you pose a question, Mehdi will think the judge has gone against
No,
him.
my lord, no.
This is not.
No, no.
These questions are put to take a proper decision.
Only, my lord, I want to point out, my lord, the journey, my lord, which journey, my lord, journey when he going to join.
So why have you excluded it?
My lord, when he
Because you are not
No, my-
taking any responsibility for his journey. Meaning there we are taking responsibility during training.
no, my lord, when he going to join in service,
Ah,
that journey, my lord, that journey.
we understand.
is-
During journey.
And
It has to be logical. That journey that they're speaking of, we understand it.
and other thing is, my lord, DRP is, my lord, as per this honorable court order. This court part is, standing order, my lord.
And his serious objection is that his case was rejected. Where is the rejection order? Rejection order, impugn order.
Impugn order, my lord, this impugn order, my lord, it was not impugn order, my lord. This order is only reflected the decision of the DRB, my lord. Subsequently, there's the impugn order, my lord. I produced before this honorable court, my lord. This was, my lord, the page 90 and 91, my lord. This order, my lord, only reflected the
What is the date of order?
date of order, my lord. This
14/9/20.
14/9/20, it is the only reflection of this recommendation, my lord.
Where is that recommendation?
This
Annexure?
Case 87. madam. Recommendation of the recommendation I have already
87?
87 only reflect the recommendation. madam.
No, no, tell us where is the
87.
MP, huh?
87.
What recommendation after going through it with see it? 87?
87, my lord, office order. madam. And recommendation, my lord, place, my lord, page 149. And finally, on 2017-2022, it was rejected. Rejection.
This is the order. Why you need to challenge DRB's decision? This has been done by Mr. Premchand Commandant on the basis of DRB only.
This reflection of the DRB recommendation.
हाँ,
And thereafter, my lord,
so we could have otherwise call for the DRB report. Why you need to challenge the DRB? Then every record you will need required to be challenged.
my
Don't make this kind of. Your order is already under challenge. That is the findings of the DRB.
yes, my lord.
Same is reflected in the order.
Yes, my lord.
So why you need to challenge?
Thereafter, this honorable court might file additional affidavit. I filed, my lord.
That is a different way.
Yes.
You can file additional affidavit. We can see from the record also.
Yes.
That is not an issue.
Yes.
After hearing at some length, this court thought it proper to ask Mr. Mojumdar, R. Mojumdar, Learned Counsel, to assist this court as an amicus. And accordingly has requested Mr. Mojumdar. First off, Mr. Mojumdar has readily accepted such request and also made certain deliberations on legal issues. First, registry to furnish a copy of the papers / records of this writ petition to Mr. Mojumdar by Friday next. Can you give a copy? Sorry to say your senior could not assist us on that day proper.
My lord, his
I asked him to sit. Sorry, I am never not given an audience to because he's fit for Supreme Court, not for courts like us. When, Mr. Rakesh? Tell us. Monday,
Monday, my lord, for this week I will not be able to.
16th? 16th?
16.
See, you get our idea. It's not that we have taken any adverse view. You just get it prepared. These will be the questions you'll have to be answered.
तो टेलीफोन स्टैंड कर तो कंपेयर
हाँ।
सर कोई भी जैसे अगर मिनिस्टर भी बने तो ऑफिसर वर्क के केस कर कुछ भी हम और मंथ का बेसिक ट्रेनिंग देते हैं कुछ सर फायरिंग सब कुछ स्किल देते हैं ताकि इन केस एडवर्स
Understand.
कुछ आना चाहिए सर बट सर इस केस पे क्या है कि सर
Training ही complete नहीं हुआ.
रिहेबिलिटेशन स्कीम है सर वो उन लोगों के लिए जो प्रोबेशन पीरियड पूरा कर चुके हैं
That is, you'll have to satisfy.
बट सर अंडरगोइंग ट्रेनिंग के तहत सर हमारे ट्रेनिंग मैनुअल पे ट्रेनिंग को सर 5 पार्ट में डिवाइड किया गया है सर इसमें बेसिक ट्रेनिंग स्पेशलाइज्ड कोर्स और इंस्पेक्शन कोर्स इन सभी ट्रेनिंग और सर ये सब किया हुआ है बट ये इस बंदे को सर ये कंफर्म ही नहीं है सर
हाँ, तो
उसके इतने
I understand. Your case is that ये तो कंप्लीट ही नहीं किया, तो इसको हम एक अटेंडेंट भी नहीं दे सकता है
नहीं।
क्योंकि इमीडिएटली कुछ होगा तो हम क्या करेगा?
सर मैं अपनी बेसिक ट्रेनिंग जब मैं करता
So therefore, you will have to answer. We accept your argument. We cannot force that if this person should be with you. We cannot direct.
Sir.
But can we leave a situation like this that a person injured gets, suppose this is a minor disability.
Sir.
Assuming, suppose a person got disability to an extent that whole life he will be in the bed.
Sir.
What will you do? Will you-
टेम्परेरी सर तब तक ये जब तक प्रोबेशन नहीं होगा सर ये टेम्परेरी सर्विस के तहत
क्या होगा तब? That is what we want to know.
कोई टर्मिनेट ही हमारे पास और कोई स्कोप ही नहीं सर टर्मिनेशन का ही है टेम्परेरी सर्विस के लिए अगर ये कंफर्म हो जाता सर
हाँ।
तो ये जो स्कीम है सर ये इसके ऊपर एप्लीकेबल होती सर
हाँ।
रिहेबिलिटेशन वाली और उसमें सर
So you
20%
want to say एक बंदा जब ट्रेनिंग में आएगा
सर।
उसका कुछ होगा
सर।
तो हमारा कोई रेस्पॉन्सिबिलिटी नहीं है.
ये-
That is what you are saying in one line.
सर सॉरी सर अब कोई भी इन सभी कोर्स जो बेसिक ट्रेनिंग के लिए आते हैं एक स्टैंडर्डाइज जो होता है सर रिक्रूटमेंट के सर उसको फुलफिल करके आते हैं सर उसके बाद सर जो सर्विस का हमारा ये 44 वीक का सर बेसिक ट्रेनिंग के लिए मैनुअल है सर फाउंडेशन कोर्स है सर ये हमें पास करना मस्ट होता है सर और 1000 रिक्रूट 25,000 88,000 लोग आते हैं सर उसमें से सर 99.9% लोग पास करते हैं
हाँ हाँ.
कुछ लोग ही पास नहीं कर पाते सर
No, that is fine. That is fine. जो लोग
सर।
पास नहीं करेगा तो हो जाएगा.
सर।
That is not an issue.
सर वो
Our
temporary-
anxiety is when a person is injured and becomes disabled while undergoing training.
Sir.
So उसका क्या होगा? ऐसा आप बोलो कि नहीं उसका कुछ नहीं. You can say that उसका कुछ नहीं. उसका हम-
confirmation ही हमारे पास
understand.
नहीं,
You should be fair.
sir, only-
We'll do what we can within the power of judicial review. We can, our powers are also
yes, yes,
limited.
yes, my friend, sir.
But we want to know, it is a policy.
Sir,
When we are living in a state
Sir.
where even hit and run cases, law are being brought in to pay compensation.
they cannot put that
Mm.
section 5 of
Mm.
CRPF Act.
Mm.
It says
Mm.
that let me come to 2D,
Section 2.
section 2D, the definition.
Mm.
I'll just try to find out what we can come to this.
Mm.
Member of the force,
Mm.
a
Mm.
person who has been appointed to the force by the command.
Mm.
Now here we have an appointment, offer appointment.
Mm.
He goes and reports for the appointment order. Whether before or after so and so includes also a person appointed to the force by the central government, whether before or after the. So if there is an offer of appointment or an appointment letter,
But your appointment letter is subject to completion of successful completion of training.
now lordship will come to 5.
5.
Before a person is appointed to be a member of the force,
Hmm.
the statement contained in the duty rules set out will be read out and the presence of the appointed person.
Hmm.
Next, provided that any person who has for a period of 6 months served with the force
Hmm.
shall on appointment to the force thereafter be deemed to be a member of the force not the DRDC, everything that they will become for for
No, no, it is not. It is
I'm
specifically,
trying to give an idea. and it says
Don't-
no,
don't
I
say
also
immediately no.
agree.
no,
Don't say immediately, no, we are not proceeding. Just he has said gulp it. Okay. But he have said gulp it and do your homework and come. Don't say immediately no. Because we are not deciding today.
Yes.
Okay. Mr. Mojumdar, you understand what
I got
is my mind in this?
whether a person idiot is injured,
Not only is your, he has become disabled. Yes,
disabled,
much
then what would be the
responsibility of the,
government or his entitlement? That is what we have.
whether this scheme or any other anything,
Anything.
or that Union of India will throw him out. Okay, go, bye-bye. Fine. You are a young boy of 19 years, 20 years, you got injured. Now, whole life you were in the bed.
I
We
heard-
don't have any response.
I heard that that a person who goes to the
Hmm.
being declared medically fit, if he is to come out
Hmm.
being medically unfit,
Hmm.
is something to
That is why, because law is in that, nowadays this is the law.
There are just
There are judgments.
trying to find out.
No, sir, I have those
which
judgments.
I was referring to. I was just trying to.
I can give you those
It
judgments.
is there.
I understand, but this, whether this,
That will do. That's why you be ready.
Yes.
Be ready. Don't make argument, so is so and so is not made parties. So and so is not under silence. These are immaterial. And don't think that we have taken a concrete view.
Yes.
We want a proper deliberation so that we can come into a just decision. Okay. And don't be so excited.
No, I'm not.
That my court case is gone
No,
from.
no, I'm not. Only I am trying to establish my case.
Okay.
Our cases are only
This
going
court
to
is always open.
Yes.
Mind it. Always open. We can change our. But you will have to have the proper answer.
full time.
Yes.
Only may pray
Perfect.
16 mile at 2 mile.
We can mention. We'll have
Because
okay, we'll have it too. We'll not write it. We'll have it too. This is our understanding. Hard in partner.
Obliged.
And you have those, if possible, if
Yes,
you can
yes,
have
yes.
if you don't file an affidavit also, if you can note it down, what are the training, what should be. See, basically we'll have to make a distinction between basic training, and that there is a distinction between a right of a person who is having not completed the training or is in a basic training, and the person who has completed the basic training. These are two different class of persons, and therefore this scheme is not applicable in Sweden. That's it.
we'll try important by
Whatsoever is required.
Yes.
On next day we'll finish it up. We'll
Yes,
not
yes,
adjourn
yes,
it.
yes.
Yes, Mr. Mojumdar.
Yes.
It is, might be a burden for you,
No,
but
no. He is expert in it.
no, we want to an assistant because he is busy in Supreme Court, he's senior. But we cannot,
Actually, he is my senior last time, afraid not to pick to them.
so what we say, what was our answer?
In his
My answer was that we do not require it.
yes, yes.
Is not it?
Yes.
That was my answer.
Okay.
Yes.
Highly.
Yes.
It was a matter of the selection and appointment of Jim Agent I was extra.
Hmm.
Moirabadi.
Somebody sought some adjournment.
Yes, my lord, I myself.
Why?
My lord, thereafter, my lord, a writ appeal was filed on the basis of the order by the division bench, my lord.
Hmm.
Some development took place in the official side, respondent side, my lord. An advertisement made.
What
text
is
made,
this order?
My lord, this part is not annexed therein. So, my lord, and another two petitions filed, my lord, it became, my lord. So I have to brought it on record, my lord, for identification. So, my
Where
lord,
is that interim order?
it is not in the IA, my lord.
IA, huh? I am in IA only.
707. There are two IA. 1107.
1107. Musumi, 1107. So 15/6/2021 was kept in abeyance.
Yes.
Then what happened?
Then, my lord, the department has made an advertisement,
Hmm.
and the process was under
What was that impugn order?
if in order, my lord, appointment of the respondent, my lord,
Was stayed.
was made.
Okay. Then what happened?
In this connection, two other registrations are filed, my lord, so I want to get brought in on the record, my lord. That's all.
Yes, who is for the state? Why you want an adjournment?
Lord, this record to be brought on record, my lord, some development took place. And
What
two
development?
other registrations filed, my
No,
lord.
no, what development?
My lord, the department has come to know the department has already made advertisement, election is made, my lord, and exactly, my lord, what the status, my lord, I have to brought on record for your,
Why? That is a new cause of action. What about your post?
my lord, the MMR, Muslim Major Divorce.
No, your respondent number 4's appointment was stayed.
Yes.
Stayed.
Yes.
Division bench says that we are not interfering with this order, interim order.
Yes.
For the reason that government has taken an undertaking that within 45 days we will make an advertisement.
Yes.
Now what about the advertisement?
Yes, that's my lord, they made an advertisement, my lord, the selection and appointment is under process. So I want to put it on record only that much, my
That
lord.
is already on record.
No,
Advertisement at page 20 and page 28.
my lord,
You want to keep it in the ventilation.
no, my lord, that is not the, my lord, none is appointed till now.
If somebody is appointed, you will have a fresh cause of action.
No, till not appointed. My lord. It is
No,
under
if
process.
appointed,
That is only it is under process, my lord. So two more registrations also are filed, my lord. They didn't think the same.
you are also not aware what to do. No, or not aware.
My lord, I will bring it on everything on record. My lord. So, my lord.
The prayer of the learned counsel for the petitioner. What will happen to the stay?
My lord, that is over, my lord, because he was appointed temporarily, and the person just come with, that's why I am asking, because to come with some false document. That's why we want to brought it on record. He is
You
perhaps not
understand, your stay of the respondent number 4 was there.
Yes.
Is the stay still operating?
My lord, what happened, my lord? After that, for permanent election, that is going on.
This is temporary.
Yes.
Division bench says you are doing within 45 days.
Yes.
They have
Yes.
issued advertisement.
Yes.
Nothing survives in this
My lord,
restriction.
but my lord, there is my lord, I have to put on record that after 1 week.
What you want to brought in record is wastage of judicial time. People are waiting.
My lord, no, my lord, what happened, my lord, in this, there are two other applications, my lord, the same is
Let that be there, that will dismiss when it comes.
my lord,
There was a challenge to a temporary appointment. Okay, this court passes an order, okay, since advertisements are there, it is stayed. Division bench says we are not interfering with the stay. How, since they are given an undertaking that within 45 the advertisement will be issued. There is no stay on a fresh election process. Fresh election process started,
Sir.
appointments made.
my lord, not appointment made yet, my lord, that's why, my lord, I am.
Suppose appointment is made, that will be a fresh cause of
My lord,
action.
not made yet, that's why,
Suppose it will be made.
my lord, I'm not on that, my lord, so I want to.
Have you, is there advertisement under challenge here?
No, my lord,
Then
my lord.
earlier
Yes,
cause of action is
yes,
over.
my lord,
Why people want to
lord,
keep
my
these
lord,
petitions on
my lord,
ventilations, we do not
challenging
know.
the advertisement
We are
is-
giving liberty.
My lord, with the challenging the same, my lord, two petitions are
Who
filed.
has filed this IA? He has been appointed.
No, my lord.
That is why so much of pendency for you people.
No, my lord, only for to bring it on record. Only one big.
What will you
I
do?
will want to dispose of.
What will you do by bringing on
My lord,
record?
this, everything,
That is already on records. I'll show you the advertisement.
my lord, the advertisement and the selection is all still in the gate. That's why, my lord, I want.
Challenge, that will be a different challenge. So this, if that be so, this has nothing to
My
be
lord.
adjudicated.
My lord, that after 1 week, but I will be taking
Day after tomorrow. Please this matter day after tomorrow.
obliged.
This is not the way. This is bad for you. The artery is clogged.
My lord, I do not know the exact position.
If it is
latest.
artery is clear, then
My lord,
we can
my lord,
decide matters.
My lord, I do not know.
Unnecessary
My
wastage
lord,
of
I do
time.
not know the exact latest status. I do not know. That's
We
why
want the lawyers to be fair.
My
See, this is the situation. Close it.
My lord, what happened, my lord?
We understand. We understand. We know. We also know.
Obliged.
So you will can see advertisement,
Where is, yes,
this is there. That is at page 22.
page 22.
This is for the post of 2 UTA.
Hmm.
That is a serial number 2 and serial number 5.
Okay.
So what you will kindly see to the office of the deputy manager, at least experience part, my lord. At least 10 years working experience as junior assistant LDA in any establishment of government and semi-government office.
This is post of UTA
UT.
in the office of the Commissioner Excise Kokrajhar.
Now, they,
Why this walk-in interview? This is for promotional post. Central selection.
now, your lord will kindly see page educational qualification we have given. We meet everything, my lord. Experience, your lordship will kindly see page 30. Has been working as PhD accountant.
What is this, sir? Promotional post or direct recruitment?
Direct recruit.
Walk-in interview.
And test was also there.
What are you doing, Mr. Chaudhary?
No, test was also there. I'll come to that.
Page 30,
Page 20, 26. This is
26.
the requirement of this petitioner number 1. HSLC, HS, BCom, masters and experience.
So you want to
certificate.
say she is having qualification and the experience.
Experience part, your lordship will kindly see that's all in government office.
Okay. Now,
Now, similarly, my lord, in respect of petition number 2, the lordship will find from page 29,
okay.
working that experience in the office of the National Health Mission, Kokal.
Okay.
Now, written test, page 33. The post contract
Hmm.
and the result to UTA, your lordship will fix at page 35, serial number 6,
Page 35.
serial number 6, UTA, 2 number of post,
Handloom
Number-
textile, soil conservation. Page 36, na?
35.
35 starts with handloom textile department BTC.
Serial number 6, Panchayat and Rural Development.
No, serial
PCA
number
2.
6 is in page 36. Panchayat and rural development.
Then result is at page 30.
So this is,
Next.
we are concerned in Panchayat and rural development.
Yes.
That is superintendent 1 post, senior assistant 2 post. We are concerned with
Yes.
the senior assistant.
Senior.
Okay, then where is the
Page
result?
35.
Hmm?
Page 35 is the result.
Just a-
Qualified in a written test, examination and viva.
30
Five.
page
35.
no 36 I have got Panchayat and rural development.
So 35 page.
35 is central board result.
Yeah.
Following roll number candidates who qualified in the written examination and viva
Viva
was
was
conducted so and so.
And-
Okay.
And page 36 is the senior assistant, total post 2, roll number 13 and 0.
Zona 13 and 0. Okay.
Petitioner.
Okay.
Now, my lord, several writ petitions were filed. I will take only one, my lord, page 47.
Post 47.
Some challenge it and we challenge it because of our non-appointment. So all these writ petitions were clubbed together and page 42 onwards, my lord. And ultimately,
Liberty to appoint issue appointment order.
last order is, my lord,
Page 48.
page 48.
Ah.
Liberty to sue.
Okay, then
So then thereafter, BTC says, my lord, page 41. Sorry, my lord, page.
page
no, that is
49.
regarding approval and all.
49 speaking order.
Speaking order is page 49.
What did they say?
It says very differently, my lord. Page 49, page 50, your lordship will kindly see. The advertisement dated so and so issued by the second paragraph. May I read, ma'am?
Hmm.
By advertisement
Cancel
number-
the entire selection.
Yes, it means that an intending candidate should have 10 years experience in working against a regular post.
Where
That
where
is-
do we get, where do you get?
Page 50, second paragraph.
Okay, the advertisement dated.
Yes, advertisement dated issued by the so and so is required to revisit here as the legality and validity of the said advertisement concerning to the experience criteria for selection to the senior assistant a cast cloud on it. It was mentioned in the experience criteria that 10 years working experience as senior assistant. No, 10 years experience as junior LDM, that is junior assistant. Under here, my lord, the main mistake has been done. Under the establishment of district level officers under PTC area is required. It means that an intending candidate should have 10 years of experience.
What the
in
service
working-
rule says?
My lord, regular post. In
Any
the
service
capacity
rule in
of
this
senior
regard?
assistant. They are saying, my lord, I am already working as a UTA.
Ah.
Why did I apply for it? Again, this is what it means.
Hmm.
I'm working as an LDA, my lord. Advertisement came, I applied for it. It's a senior. I am working as a LDA. Here they said you are working as a senior assistant.
Hmm.
So therefore, why should you apply for that post? In the capacity in the district level officers area. If that be so, naturally question arises as to why a regular senior assistant
Hmm.
who is already holding the same cadre of junior assistant, I am junior at his respective office shall come and participate in the state interview process in order to get selected and enjoy a pay slip which is much lower than the salary he has been enjoying in the same cadre for last 10 years. In the same advertisement, it is found that the CBSE PTC has prescribed criteria for selection to the post of UTA comes to 10 years experience of working as junior assistant LDA in any establishment government of Assam in a common advertisement for the same post. Two different criteria cannot be fixed by the CBSE PTC under the given circumstances. This is clearly a non-application of mine shown by the CSP PTC. Besides, the advertisement asks for experience from regular senior assistant. It doesn't say so.
What is the advertisement?
Advertisement is a page number 20. At least 10 years working experience as junior assistant LDA in any establishment of government of Assam. Same
So you were
is-
junior assistant.
Yes, that's
Whole premises is wrong,
wrong.
according
Both
to you.
premises-
They say that why are you coming to us when you have already UDA 10 years
UDA.
experience, you are getting higher scale of pay.
Yes.
And what is your job?
After all this, my lord, after contempt close
And
and all,
second condition is that you are not having working in appointed under scheme. Where is your experience certificate?
one experience certificate in respect of petition number 1
Hmm.
is page 26 to 29.
$26.
That is the their working experience below it is there. Supporting documents are also. 4 years experience as LDA cum accountant proficiency in district primary education program. More than 4 years experience as LDA cum accountant proficiency in Sarba, Shiksha, so and so. 7 years running experience as a block accountant, account manager, Balajan, PhD, Kokal. The above mentioned particulars which I absolute. That certificates are there. Next, 27, 28, 20. In respect of petitioner number 2, page 30.
Yes, Chaudhuri, government or semi-government?
That also my
Set
lord,
aside and go back, take a press call. Or these persons are appointed, post are fill up.
Oh, no, Lordship, the process has been cancelled. That's the issue.
No, no,
Whether the post
selection
will be-
process cancel, you have a right to cancel.
Yes, ma'am.
Because the order says you may now issue the appointment. We have no problem on that. If you give a good reason for cancellation, we don't have any problem because there is no mandamus to appoint them. Now, question is, you cancel their appointment on absolutely wrong premise.
Yes, there, Lordship.
If that will go take a fresh call in terms of the earlier order. That's all.
Yes.
Isn't it? Here it says that 10 years working experience as junior assistant or LDA in any establishment of government and semi-government. They are under DPEP, it was a project under government, state of Assam. They were working under some and other. So, and the expert committee has decided them to be a semi-government or government whatsoever. Who is the secretary to cancel on that ground? Take a press call.
the lord direct them,
We'll direct them, but we'll not. We cannot issue an appointment order.
not appointment, not direct them to issue a order.
They will, because we'll set aside this order because this is absolutely non-application of mine. What was the advertisement and what is their finding is totally different. So this is absolutely non-application of
also-
mine.
2 read petition, 1 contempt petition, then thereafter they pass. The
So
lordship
it will, this will
if
be set aside and they will
direct
pass a
for-
fresh direction in terms of the earlier judgment within a specific time. That's all.
for
That is earlier orders, there is no direction. Let us not go to that judgment because your right has matured on the basis of
within a
the
stipulated time.
earlier judgment. So that what is what right is accrued, that can be a determination in different issue because
Within a
there
period,
is something different.
short period, if the lordship is there.
Heard Mr. P.D. Das, Learned Senior Counsel for the petitioner, also Mr. B. Chaudhuri, Learned Standing Counsel for the petition. What is your affidavit? What is your stand?
Paragraph 37, basically the speaking order, Lordship.
Okay, that
As you can-
you, no affidavit is required because you have disclosed your reason.
Yes, ma'am.
You cannot. Mr. Das will slowly dictate in the chamber. Okay, this will be the order.
In order to satisfy.
Putting in order will be set aside and they will take a call, fresh, they will do the necessary exercise in terms of the earlier judgment within a period of tell us the figure.
Lordship, 2 months.
Too much. Voice is having some problem, so I'll slowly dictate. Okay. So you may get this order tomorrow also.
Wait, please, Your Lordship.
You take your seat.
Hello.
You are not lucky. Now today the voice is having it. To dictate all this. We may not rely on any judgment. We may give the principle. Any objection? Subject to what? We are in your favor, right till now.
I'll take my lord the charge sheet, the allegation, the
Hmm.
charges, his reply, my lord, his written statement to the charges, and the report, inquiry report.
Hmm.
The charges are threefold, my lord. My lord, may kindly have the charge sheet,
Hmm.
starts at page 24.
Hmm.
Charge number 1 is habitual negligence of duty. 2 is theft, fraud, and dishonesty in connection with the business of the port. 3 is breach of the ACP officer's conduct.
Did we dictate something?
No.
No.
Now, the statement of allegation is at page 25 thereafter.
Hmm.
Charge number 1, I'm
Hmm.
reading, madam.
Hmm.
Habitual negligence of duty. Sri Jugenda submitted earned leave application, so his
Just
so basically, my lord, unauthorized absence, my lord, for three periods.
Hmm.
The periods are, my lord, there is a period of 10 days,
Hmm.
which is from 15 February 2008
Hmm.
to 24th February 2008.
Hmm.
Now, the second period, my lord, thereafter is for a period of 28 days, which is from 5th March
March to
2008,
31st March.
31st March. That's right. And then, my lord, there is an absence of 5 months
Hmm.
from 3rd March 2008 to 11/7/2008, when he actually rejoins work, my lord.
Third, where do you get that?
My lord, below charge number 1,
Charge number below, charge number.
yes, my lord, para 1.
Okay. That
Thereafter-
remain absent from 3/3/2008. No.
And by only joined by his letter dated 11/7.
Okay.
So there is 3 periods, my lord, of unauthorized absence.
So it is from 3/3/2008 to 11/7/2008.
Now, my lord, this is the first charge.
Hmm.
I'll straight away take my lordship to his how he's dealt with this charge in his plea. It's very haphazard, my lord. Somewhere he talks about charge number 1, somewhere he talks about charge number 2. So it is a little difficult to, my lord, tell you first.
Okay.
Now, page 30, it is written statement.
Yes.
Now, second paragraph, last sentence, my lord. It says, my controlling officer did not believe me that I was suffering from chronic sinusitis
Hmm.
and also had undergone operations once in an acute state that was giving me strong headache, frequently in the above, that was Recording. So thereafter, page 31, second paragraph, my lord. 8th line from the bottom.
Second line.
8th line, page 31, 8th line from the bottom. My lord. Okay. So, my lord, the charge,
SD.
the charge is very concrete, my lord.
Hmm.
He remained absent from 10 days, 15 days, and thereafter 5. Now, how he deals with this? He says the SD used to refuse my EL applications and would ask me to submit earned leave application. If I would submit EL application, then he used to ask me who will take charge. This is his dealing with the charge. Then thereafter, my lord, again at page 34, first paragraph, sir. Only paragraph. The 4th line from the top. Thus I felt
unsecured gradually and my sinusitis.
When?
Fourth line from the top, my lord, page
Okay.
34.
Okay, thus,
Thus I fell unsecured gradually and my sinusitis problem also aggravated, giving me strong headache. On 14th February 2008, I submitted.
problem is the English line.
Copy
ought
not
to-
be-
Ought to have been written in
active.
Assamese, Assamia. That's why official language should be Assamese. Anyway.
I had submitted one CL application before the SD Golakganj
Hmm.
and went to Guwahati. Met your honor at your office on so and so and returned to Golakganj on 24th February 2008. I requested the SD then to allow me CL and restricted holiday on those days of my absence. The SD refused my request and asked me to submit some other day. Now, again, my lord, that very same paragraph at the bottom, my lord, will see it says, I had to visit Gauripur Community Health Center.
Well,
Middle of the paragraph, my lord. I had to visit Gauripur Community Health Center on 4th March.
okay. I had to
Treatment.
visit Gauripur Community Center on 4th March.
So thereafter, he says, well, next line thereafter, I felt essential to get better treatment at Guwahati and thus submitted 2 EL applications with effect from 5th March 2008 to 31st March 2008 and sent 2 telegrams thereafter for extension of my EL, which cannot be treated as an authorized leave. But the senior manager refused my EL application and reported the CCMD that the application was not acceptable. I don't know why the senior manager was reported directly for this. Then thereafter, my lord, page 35. Thus, it was apparent, first paragraph. Thus, it was apparent that my leave applications were refused by the SD, senior manager, as well as
Done. Page 35,
35, my lord, the third line.
third line.
Thus,
Okay,
it was apparent that my leave applications were refused by the SD, like senior manager, as well as refusal to arrange the takeover charge of so-and-so, but blame me that I have undergone unauthorized leave and not handed over the charge, whereas I had nothing in my charge. After taking treatment at GMCH, I went to Golakganj again on 3/7/2000. Now, this is an admission. Now, how the inquiry officer deals with this charge? The inquiry
This is
report.
unauthorized absence.
Yes.
Not one side.
And
We-
what were the others? Sajid?
The
Other side,
second,
matlab, application of 97,000. And out of 97,000. That departmental information.
Okay, that
But,
part.
for common debt matter is 73,000. Again, my lord, by the one that report was placed before the disciplinary order, then disciplinary order is to second focus on. And I replied to them, my lord, then my lord, the disciplinary authority found no, it's not 79,000, it is 37,000. So what has been held by the disciplinary, my lord, inquiry? My lord,
According
this
to you,
is not there.
it could not be determined. Anyway, okay, we'll come to that later.
Yeah. but otherwise, on that point alone, otherwise the disciplinary authority is not in agreement with the findings of the inquiry officer, they can very well.
Yes.
They can
No
very well
problem, no
defer over it.
problem.
Yes, and all they have to do is issue a show cause notice, give him a hearing, which has been done in. Now, how this charge, my lord, is dealt with in the
Inquiry report.
Yes, that inquiry report starts at page 41. Again, my lord, I'll not bother my lordship with reading the entire inquiry report. I'll just take my lordship to the page 42, which is the reiteration of the defense plea. Page 42.
I'm at page 41.
Yes.
Okay, page 42.
42 is the defense plea
with
regard to charge number 1, which is unauthorized. The charge officer mentioned that on 14 February 2008, he had submitted a CL application to the SD and went to Guwahati. He returned to Golakganj on 24th February 2008 and requested the SD to allow him CL and restricted holidays for the days of his absence. The SD refused to accede to his request and asked him to apply for some other kind of. He submitted an application for sanction of earned leave on 26th.
No, that we have already gone. Where
Yes,
is your finding?
Yes. Now, my lord, the finding,
Hmm.
page 43 onwards is the evidence.
Okay.
Now, the finding as far as charge number 1 is concerned, my lord,
Hmm.
starts at page 45.
Hmm.
The finding, the
Hmm.
finding.
Hmm.
Start.
Hmm.
It is admitted by the charge officer that he left for Guwahati on 14 February 2008 and returned to Golokganj on 24th February 2000.
Hmm.
It also appears from his letter dated so-and-so addressed to the SDE that initially he applied for CL from so-and-so from 15 February 2008 and 18 to 20th February 2008. By exhibit letter so-and-so, he applied for restricted holiday from 19 February 2008 to 21st February 2008 and CL leave from 22nd to 25th February 2000. It is thus clear that the charge officer left headquarters on 14 February 2008 and remained absent from 15 to 2008 to 24th or 25th February 2008 by submitting an application for CL for 4 days without even bothering to obtain permission to leave headquarters or sanction of leave. This part of charge number 1 is C, that the charge officer submitted an application on 26 February 2008 for earned leave on medical grounds from 5th March 2008 to 31st March 2008 without any supporting medical certificate, and that he remained absent at least up to 11/7/2008 is not denied by the charge. He claimed that he sent 2 telegrams for extending his earned leave, but there is no supporting evidence to substantiate this claim. Again, since he applied for earned leave 1 week in advance, obviously there was no emergency. He should have therefore thought into it that the leave applied for the sanction or was sanctioned or at least recommended. He should have also handed over charge after ascertaining from his controlling officer as to whom he should hand over charge. Apparently, he did nothing of this sort and just stopped coming to office from the date he applied for leave and continued to remain absent much beyond the period of leave applied for. This is surely subversive of this part of charge form. Now he admits to his not being there, man. He admits to
So
being
unauthorized absence.
is proof for 3 periods. As far as charge number 2 is concerned, my lord, I'll again, my lord, take the first page 25 again.
Page 20.
Page 25 again, my lord, this with regard to charge number 2. Theft, fraud,
Dishonesty.
dishonesty in connection with the business of the board. The Jogendas so-and-so received an application for 12 numbers of village of Pastiwari Tumbagan and Lalmati Tumbagan on 31st December 2007 and 30th February 2008 for electricity connection of their premises. Accordingly, the prospective consumers paid rupees 12,000 only to him for service connection. But he thus FME did not bother to take necessary action on the said application. 2. As Mr. Das has misappropriated board's revenue to the tune of 91,138 by manipulating false RT numbers. RT numbers is receipt numbers against the name of consumers with fraudulent motive for his own wrongful gain. Now, thereafter, Malin also find a table which has 21 entries. Now, so my lord will kindly see very relevant, my lord. The third column is very table. South Raipur, so and so, so and so. So this there is a date, my lord, 29th August 2007.
Which one?
My lord, the table that at page 25.
Huh.
Column number 3.
Amount.
No, my lord, name of consumer and RT number.
Color number 3. Okay.
Yes. So there is a mention of a date. These all dates, my lord, pertain to the year 2007, 2006 onwards, going up to 2008. Why I'm saying this is relevant, I'll come to that later. Now, 21 entries are shown, which say that these entries were wrongfully made and he had misappropriated amount of 91. Now, what does he say, Manoj, in his reply? Now, page 35.
35?
Yes.
Yes.
Bottom of page 35, last paragraph. in
Please
the-
respect of something.
I would like to state that I have received the application for new service connection, only those endorsed by the SDE.
Mm.
I have prepared the estimate, 36 months.
Ah.
I have prepared the estimates of those prospective consumers and submitted before the SDE, who held up the release of the service connections for not getting bribed from. As those consumers made pressure, he insisted them to lodge complaint against me, and they have paid money for the estimates already to the JE. It is almost impossible, sir, to believe that why a group of consumers shall pay me the entire amount of service connection bill and an amount of bribe for a JE instead of deposit at cash counter of the subdivision, or they could lodge an Ezahar against me at local PI. Such an allegation framed by the SDE is hard to believe by anyone. Such conspiracy of the SDE made me unstable, always in the subdivision. He was always threatening me rather to collect money from the service connection applicants, and a portion of which will be sent by him to the senior. He also used to threaten me always that if I didn't respond, I will be sent back elsewhere out of this division. As I have stated herein above earlier, the SDU chose among some applicants to prepare the estimates by the other staff of the subdivision and release of the new service connections, of which it was easy to negotiate by him with the applicants for extra money for him through many agents available under the subdivision. If your honor would requisition,
Requisition.
yes, requisition all of the service connection estimates during my tenure at Golapganj and verify the handwriting, the truth will come out. We have also learned that the SU knew that those areas of 12 numbers of applicants will be handed over to Gosaigaon Electrical Subdivision. He planned to set them on me after collecting the complaints. As such, conspiracy of the SD and senior manager had nothing documentary proof, but they were able to collect such complaints from the applicants so long they were in the chair of power. Therefore, such wordless allegation may kindly be dropped by your honor, that were obviously without having any merit. In respect of the allegation of misappropriation of the post revenue of rupees 91,138 by manipulating false RT numbers, I am enclosing a statement herewith at page as an extra so and so, which he has not even filed with this request. I have personally visited Golapganj Electrical so and so on 24th November 2008 to 29 November to find out records related to all my allegations brought by the senior manager and failed to find out all records. It was surprising to me that few documents were made non-available to me. Your instructions in this regard by your letter dated so and so may mildly be referred to. However, the records which I could recover and are enclosed as so and so in the form of statement for your kind perusal. Most of the records found correct are envisaged by the SDE. Golapganj misstated your honor to book me for misappropriation. It is to be mentioned here that the cashier of the subdivision used to utilize outsiders in collection of cash, because the cashier used to contact the prospective consumers, help them in negotiating with SDE, and also sometimes by preparing service connection estimates. The handwriting of the subsidiary cash book and the estimates may kindly be inquired for verification. Such illegible handwriting of subsidiary cash books were always misleading in the realization and correct posting of RT numbers, which may kindly be.
Where is the finding?
Yes.
Finding?
Yes.
Page 47.
46 of.
Hmm.
Now, part of charge number 2. The allegation is the charge officer received 12 numbers from 12 consumers for providing service connections to their premises, but did not take any step in this regard nor deposit the money in the office. The charge officer mentioned in his written statement that he received only those applications which were passed on to him by the SDE, and that he did not receive any money.
So
And-
12,000 is gone, according to the inquiry.
Yes.
Okay. What about B?
Yes. Now, against the allegation of misappropriation of the board's revenue to the extent of 91,138, the charge officer furnished a statement in an attempt to explain the discrepancy as pointed out in the inspection report of the accounts officer. His explanations are, however, not supported by any documentary evidence. Moreover, many of the explanations are somewhat vague. Example, item 1, 2, 3, and 4 of Exhibit 7 mention 4 amounts against 4 different SPPS consumers. in the ledger, all of which are mentioned as realized against receipt number 402 of 417 dated 29/8/2007. The comments of the account officer in this is that the receipt numbers as recorded in the ledger is false. The total amount under these four items comes to rupees 28,495. The charge officer mentioned in Annex 11 of his written statement that rupees 28,000 was paid in two installments, rupees 27,000 and rupees 1,000, and the balance to be carried over. As mentioned above, the four items relate to four different consumers, and the amounts involved are 23,342, 520, and 2,004 and 330. The charge officer not only did not furnish any documentary evidence to prove his point, but also did not care to explain as to how these two figures of rupees 27,000 and 2,000 were purchased. Again, if the balance, that is rupees 495, was to be carried over, the charge officer did not explain as to why it was shown as realized in the ledger. The whole thing appears to be imaginary. However, items number 5 and 7 of the exhibit 7 relate to the period of February and March. The charge officer mentioned that the entries were not made and the handwriting is not his.
So let us go to the, which are proved now. Let
Yes.
us go to the page 25.
Page 25.
Hmm.
Now, page 20,
12,000 is gone. Where is it?
12,000 is gone.
Okay, 12,000 is gone.
5 and now there are 21 entries, my lord. Now 5 and 6 are not. 5 and 7 are not.
Not good. Okay.
Because it says at page 47, so this part of charge number 2 has been proved, except for item numbers 5 and 7 of the list mentioned in the statement of fact.
This was according to a period where petitioner is not
Is
available.
not. Now charge number 2 is again, my lord, is a offshoot of the charge number 1 and 2, which is a violation of the ACB officer's conduct. Now, what the petitioner basically, my lord, has projected before my lordship
What was the punishment?
punishment, my lord, the proposed punishment was one increment. Property of that.
Where is the then order, interim order?
It's at page operative portion is at page 54. And third line from the top, I conduct record to look at so the inspector thereby bill with an amount for 1,000 out of 7 of the could be place of application by the company, but for the company. Therefore, if you examine all such certain detection the search to power consider regulation by new power.
No, the finding is, I have conducted detailed inspection of relevant revenue records of Golokganj Electric Subdivision pertaining to this case through competent officials. The inspection finally revealed that an amount of 4945 could be traced to have been received by company, but with different receipt number and date. What this mean, different receipt number and date mean?
On their initial that statement that entry is wrong. That they on the basis of which.
Now meaning thereby
Yes.
that this does not relate to this address receipt number.
This is
the amount, my lord.
Huh.
The 21 entries
Huh.
were found, my lord, in the statement of application.
No, there are 21 entries in statement of
My lord,
allegation
were gone
and
away.
total amount totaling 91,138.55.
No, my lord,
My-
Isn't it?
correct. Yes.
Huh?
Here,
But
yes,
just understand.
Yes.
According to the source sheet, it is 91
91,000 it was, my lord.
130.
138.55 as per the list,
Yes.
21 list.
Including the 12,000 So it was 78,
Okay, including the minus 12,000.
it was 78.
78,000 something. Okay. So this is 78,000.
Yes.
Now this is 78,000 and odd.
As per
Okay.
the inquiry report,
Now enquiry report, what is this?
inquiry report says entry number 5 and 7,
So if
Have
entry
to be-
number 5 and 7 is deducted, then what is to be the amount?
That's 78.
78,130.
Just a minute, 71,000?
78,000.
No, no. The allegation is of 78,000 from the list.
A total allocation of 91.
Forget about that. We are not on 12,000. That is, they have also, authority also said that 12 is gone.
Yes.
Now, out of 78, what should be the amount? Minus cross 91, 130.
546 rupees and 500. So 1,046 rupees has to be deducted. 91. So 90. And minus
No,
12,000, that
no, no,
66.
no. You will have to deduct correction 91, 138.
Yes, sir.
0.55 minus 12,000. No. লিখি ৰ'ব এখন লাগিব। 79,000.
Minus another 1,000.
Then minus আপনি করো
entry 500 and 546. 1,040.
13,000. No, 7,000. 5 is 7,000 and 7 is 6,000.
Yes, yes.
13,000. 7 again minus 13,000. So it is 60, according to the enquiry officer, 66,138. Now come to the report. Come to the punishment. Let us read it. I have
Yes.
gone to the case record.
Fine.
Okay.
I have conducted detailed inspection of the relevant revenue record of Gologanj Electrical Subdivision pertaining to this case. Competent officer. The inspection finally revealed that in amount of 40,000 out of 70,000 and of said to be untraceable could be traced to have been received by the company, but with different RT number and date. 40,000 again they have discovered.
Received.
Yes, received.
So what was the amount? 71,000. Earlier, what was 78,000? How did they get it 78,138?
Yes, because
Okay, forget about for the timing. Maybe calculation mistake. Now, what is the meaning of this? The inspection finally revealed that an amount of 40,945 could be traced to have been received by the company, but with different
RT number.
RT number and date. What does it mean?
They say that the amount was different. received
So,
by the
which
company.
are those amounts? If that is, we are not understanding anything. So, this is an altogether new inspection.
So it is an
Conjecture is that-
inspection matter
that might-
because the authorities said that they were not in agreement with the findings of the inquiry.
Understand? But if
So
you
they can-
if they can say that, see, your findings on the basis of this evidence will not accept, but actually this evidence leads to this. No problem on that. There is an evidence. A trial court decides something. We as an appellate court say, no, evidence is, this evidence interpretation should be this only. No problem on that. So therefore, we give a different decision. Can we have a fresh evidence in a of course, under CPC and CRPC, we have a power to have a fresh evidence with a right of cross examination to the other. But here in this case, the person has had satisfaction is not on the basis of the materials already available on that.
Correct.
Yes.
The satisfaction is on the basis of material collected by some other official. Isn't it?
Competent officials, but it
But
is-
we are
yes,
not denying
yes,
that.
yes.
It
Also
is
the-
by a competent authority, which is so therefore, this could have been
Present.
giving him a chance. Then, no, this is actually
He has been given a chance. He's been heard. He's replied to the show cause. Now,
no
my-
reply to the show cause is two part. It's to satisfy us.
Yes.
There are two part. One is that on the basis of this evidence, I take a decision. The employer says, no, we are not accepting your decision. This is the material, so this should be the conclusion. You have the power, and therefore you'll have to ask him, yes, though this has been taken, this is our view, what you want to say.
Yeah.
Here your case is, that is not your case. Your case is that beyond the inquiry report, we have had our own calculation by competent authority, and we got this out of that, and which is no mention of those RT numbers in the
It
search it.
does not say beyond the,
Beyond the, because but different RT number.
or
That
the
is the
amounts put were tallied and the amount they said, but the amount.
So therefore, your charge is defective. Already there are some amounts already received.
The amount was.
Different
no,
RT numbers were there.
The finding or the reduction.
So you
of
have
the-
taken a conclusion on the basis of additional evidence,
Or the.
which is
evidence
not
on-
part of the, which
No,
were not
it is-
part of the
perhaps it is not the case.
enquete. So whether that is permission.
Perhaps it is not the
If
case.
not, then let us not argue on that.
Or
part.
perhaps that is not the case.
Hmm?
Because I'll try and satisfy your lordship of it. Because the subsequent inquiry or the. or
No,
the record
one
that
thing
we-
remains.
Yeah.
One thing remains that the decision arrived at by the employer or difference of opinion of the employer is not solely based on the evidence of the inquiry, rather its own satisfaction on the basis of material collected through a competent officer.
Because these materials were there before the inquiry officer.
Does not,
Because it's the findings of the competent authority or the
but
department.
they have done another exercise.
Because they were
It's
not
not that
satisfied.
these are the materials inquiry report, I go through the record. No, these are the materials which are not part of this.
Because Melody, my lord.
Anyway, you proceed.
Yes, it's because the subsequent Melody finding.
Okay.
Melody was,
Hmm.
Melody was looking into the penalty, order of penalty.
Hmm.
At page 53.
Hmm.
Melody, if I can just read portion of the order,
Hmm.
perhaps that would throw some light into
Okay.
the. Now, Melody, the fifth account was number.
Fifth para,
P.
Sri
Jogenda
Jogenda.
SC, JE was
Hmm.
served with a second show cause notice by so and so dated so and so, calling upon him to show cause if why he should not be inflicted the proposed penalty of reduction of pay by pay increment with realization of a misappropriated amount of 78,138.55. Mr. Das was also given an opportunity of personal hearing on 15th March 2010. He thus submitted his written reply dated 14/10/2009. The second proposed is, I have gone through the written reply dated 14/10/2009, submitted by so very carefully, and so was heard in person in my office chamber on 15/2010. During the personal hearing, he has attempted to deny the alleged unauthorized absence by asserting that he maintained all the usual formalities, including sending of 2 telegrams time to time to the SDA concerned. But it is found that these were not relevant to the period for which charges were leveled against him. Regarding wrong entries of money receipt numbers and date in the industrial ledger, causing loss of revenue to the company, so and so could not give any satisfactory explanation for incorrect / non-existent RT numbers / dates entered in the corresponding ledger. However, he asserted that all such amounts so entered have actually been received by the company from the respective consumers. I have gone through the case record and I have duly considered the explanation in writing given by the charge officer as well as his oral submission before me in the personal hearing. In the above consideration, I have conducted detailed inspection of relevant revenue records of Golabganj Electric Subdivision pertaining to this case to competent officials. The inspection has has finally revealed that an amount of rupees 40,945 out of so and so said to be untraceable could be traced to have been received by the company, but with different RT numbers and dates. Therefore, having examined all such related issues and ascertaining the extent of irregularities committed by the charged officer, and in exercise of powers conferred upon me under Regulation 10 of the AECB General Service, Regulation for Officers 1960, I do hereby order to inflict the penalty of reduction of pay of so and so by one stage, which is one increment, with cumulative effect, and recovery from him for an amount of rupees 37,194 in 9 monthly equal installments of rupees 4,000 and rest amount of 1194 in one.
Hmm.
Now, my lord, the inquiry report goes on to hold that there is misappropriation.
Hmm.
Only 2 entries were found not to be proved, and the amount was a certain. It could be 78,000, could be 60. Now, also the proposed penalty was for a proposition of penalty of pay increment, reduction of pay by pay increment. Now, here, my lord, after taking into consideration every fact, all the documents, and this does not say that they conducted a separate inquiry or they went on to go look at different materials or records that were not before the inquiry. There is no whisper of. Even the petitioner has not said that in his written. Now, what the competent authority has done, my lord, they have looked at the material facts. The charge with regard to unauthorized absence has remained as it is. He could not disprove it. Now, when it comes to the recovery of the amounts were misappropriated, the authorities came to a fair conclusion because the original amount was far greater than the amount that was actually involved. So, in a sense, my lord, he has not been prejudiced. It has actually, the competent authority has come to the petitioner's rescue. The amount was reduced.
You say that they properly applied their mind,
Right, yes.
and this decision was just.
Just
So
and fair, my
therefore,
lord, and no prejudice has been caused.
In a exercise of judicial review in a departmental proceeding,
Yes.
court will not sit as an appellate authority. Will look into whether there is a procedural
Impropriety or, my lord, violation of the principles of natural
natural
justice,
justice.
or, my lord, if the findings are based on no evidence whatsoever. Now, here there is evidence. There's legal evidence which perhaps cannot be reappreciated. Now, as far as the recovery amount goes, my lord, the amount of out of the 37,000, 36,000 has already been recovered. Now, petitioner,
Recovered from his salary or
there has been a stay prior to the stay, my lord, because he approached the court late. Now, on the basis of the petitioner's contention that the recoveries were not made, my lord, an interim order was passed saying that no further recovery should be made. But what was not projected and what was not placed before this honorable court is the fact that, my lord, already a recovery to the tune of 36,000 had already been. All that remains is that 1194. Now, the petitioner has not, my lord, given these facts, my lord. These are somehow not missing from the report, which is that the recoveries have already been made, my lord, to the tune of 30. He has not disclosed that. And, my lord, petitioner also, my lord, in his petition, he has projected a case that despite his repeated requests, my lord, he was not allowed to inspect or not given certain documents, which would have otherwise, he says, would have helped him put forth a better defense. Now, what are the documents, my lord, that he is seeking? My lord? Page 29.
Yes.
29 of the report. With reference to the subject cited above, I have the honor to request you to provide me to inspect the rural industrial consumer ledger for the period from December 2005 to February 2006 by letter number so and so. My lord, my submission with this document or this inspection that the petitioner has sought for, these are completely immaterial and irrelevant and has no bearing on the finding or the charges leveled against the petition.
Because
Why I am
this is a
saying
period prior.
period prior to the NPT. So this is basically a
And
petitioner
this, Mhm.
is attempted to say that he has been prejudiced and because he has not been given these documents. Now the law as it stands, my lord, is that the departmental authority or the inquiry officer is not required to furnish irrelevant or documents which are absolutely have no relevance with the department. I also have judgments that one second, please. Now, I can straight away. Okay. The first judgment, my lord, is Union of India and Others versus P. Gunasekaran, 2015 to SCC 610.
2000.
2015 to SCC 610.
Paragraph.
Paragraph 12 and 13. May I just read out
Yes.
the bottom of para 12 now. The High Court, in exercise of its powers under Article 226/227 of the Constitution of India, shall not venture into reappreciation of the evidence. The High Court can only see whether A. Inquiry is held by a competent authority. Inquiry is held according to the procedure prescribed in that behalf. There is violation of the principles of natural justice in conducting the proceedings. The authorities have disabled themselves from reaching a fair conclusion by some considerations extraneous to the evidence and the merits of the case. The authorities have allowed themselves to be influenced by irrelevant and extraneous considerations. The conclusions of on the very face of it is so wholly arbitrary and capricious that no reasonable person would ever have arrived at such a conclusion. The disciplinary authority had erroneously failed to admit the admissible and material evidence. The disciplinary authority had erroneously admitted inadmissible evidence which influenced the finding. The finding of fact is based on no evidence. Under Article 226-227, the Constitution of India, the High Court shall not reappreciate the evidence, interfere with the conclusions in the inquiry in case the same has been conducted in accordance with law, go into the adequacy of the evidence, go into the reliability of the evidence, interfere if there be some legal evidence on which finding can be based, correct the error of fact, however grave it may appear to be. 7. Go into the proportionality of the punishment unless it shocks its conscience. That is the first judgment. And now the next judgment, my lord, is 2021 to HCC 612.
Paragraph.
Paragraph. Now, this is a judgment rendered by a 3 judges bench of the honor.
Paragraph.
Paragraph 22 to 25. The power of judicial review in the matters of disciplinary inquiries exercised by the departmental appellate authorities discharged by constitutional court under Article 226 or Article 32 or Article 136 of the Constitution of India is circumscribed by limits of correcting errors of law or procedural errors leading to manifest injustice or violation of principles of natural justice, and it is not akin to adjudication of the case on merit as an appellate authority, which has been earlier examined by the court in so and so. 23. It has been consistently followed in the later decisions of this court in so and so and recently by so and so. 24. It is thus settled that the power of judicial review of the Constitutional Court is an evaluation of the decision-making process and not the merits of the decision itself. It is to ensure fairness in treatment and not to ensure fairness of conclusion. The court/tribunal may interfere in the proceeding held against the delinquent if it is in any manner inconsistent with the rules of natural justice or in violation of the statutory rules prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding be such as no reasonable person would ever have reached, or where the conclusions upon consideration of the evidence reached by the disciplinary authority are perverse or suffer from patent error on the face of record or based on no evidence at all, a writ of certiorari could be issued. To sum up, the scope of judicial review cannot be extended to the examination of correctness or reasonableness of a decision of an authority as a matter of fact. 25. Whether disciplinary or inquiry is conducted for the alleged misconduct against the public servant, the court is to examine and determine whether the inquiry was held by a competent authority, whether the rules of natural justice are complied with, whether the findings or conclusions are based on some evidence, and authority has power and jurisdiction to reach finding of fact or conclusion. Now, on the point of evidence, my lord, sufficiency of evidence,
No, there is no quarrel on that.
yes, just place them, my lord, for my consideration.
Okay. Paragraph.
Other judge.
Okay.
This is 2022 SCC
Hmm.
130, para 6.1. It is a settled law that interference with the orders passed pursuant to a departmental inquiry can only be in case of no evidence. Sufficiency of evidence is not within the realm of judicial review. The standard of proof as required in a criminal trial is not the same in a departmental inquiry. Strict rules of evidence are to be followed by the criminal court where the guilt of the accused has to be proved beyond reasonable doubt. On the other hand, preponderance of probabilities is the test adopted in finding the delinquent guilty of the charge. Now the judgment thereafter, 2001 SCC 416, para 60. The last sentence of para 60. The settled legal position is that if there is some legal evidence,
Paragraph 16.
yes, ma'am. The last sentence of 60, the settled legal position is that if there is some legal evidence on which the findings can be based, then adequacy or even reliability of that evidence is not a matter for canvassing before the High Court in a writ petition filed under Article 226. Now, my lord, I also have two judgments with regard to not providing, there is no necessity for providing irrelevant documents. Should I place that? The first is 1996 5 SCC 47. Nineteen 96 5 SCC 47.
1996.
47.
Paragraph.
Paragraph 4, my lord. Classicum C, my lord, that now remains only the third ground.
Hmm.
Now remains only the third ground is the non-furnishing of the documents asked for by the respondent. The tribunal seems to be under the impression that the inquiry officer, disciplinary authority is bound to supply each and every document that may be asked for by the delinquent officer / employee. It is wrong there. Their duty is only to supply relevant documents and not each and every document asked for by the delinquent officer employee. Thereafter, my lord, it is in this regard, it is not brought to our notice that the respondent did so. The tribunal too has not gone into the question, nor has it expressed any opinion whether the document asked for it or were indeed relevant and whether the non-supply has prejudiced the respondent's case. The test to be applied in this behalf has been set out by this court in State Bank of Patiala versus S.K. Sharma. It was the duty of the respondent to point out as to how each and every document was relevant to the charges or to the inquiry being held against him and whether and how their known supply has prejudiced his case.
Yes.
That next judgment matter with 2002 TSTC 443 number, para 11. 2002 TSTC para 11 matter. Learned counsel for the appellant has further submitted that the particular documents, copies of which are said to have not been supplied, are not indicated by the respondent, much less in the order of the High Court, nor has the relevance been pointed out. The submission is that the delinquent will have to show as to in what manner any particular document was relevant in connection with the inquiry, and what prejudice was caused to him by non-furnishing of a copy of the document. In support of this contention, reliance has been placed on a case reported in Sattama Tiwari versus Union of India. It has been observed in this case that the obligation to supply copies of documents is confined only to material and relevant documents which may have been relied upon in support of the charge. This order observed that if a document, even though mentioned in the memo, this is not relevant. It has been observed that in the case that the obligation to supply copies of documents is confined only to material and relevant documents which may have been relied upon in support of the charge. Now, my lord, petitioner has also alleged that the entire proceeding and the finding there are perverse. Now, my lord, perversity cannot just be pleaded, my lord, they have to prove it. On the question of perversity, my lord, I'll rely upon a judgment of our honorable court. It's very honorable, the division bench of our honorable court. 2016 to GLT 467.
Paragraph
Paragraph 27, 28, 29, 30, and 34.
27 to
27 to 30, and then 34.
yes.
Oh, well, I'll not trouble myself, my lord, with 27 to 29.
These are
30 is
the-
important, my lord, with regard to purpose. Now, in General Managers Punjab and Sindh Bank versus Daya Singh, reported in 2010, 11 STC, a perverse finding is defined as one which is based on no evidence, or that no reasonable person will arrive at such finding. So this is the definition. This is the principle that
Hmm.
concept of purpose. That is, respectfully, my lord, that is not the case.
Okay. That's all.
Sorry,
Yes.
my lord, page 65.
Yes, you can rephrase your argument. Also, no
Okay.
problem.
My lord, so far that 25, 21 number of entries are concerned in the
Just a
30.
minute. Just a minute.
Yeah.
Hmm.
20 number, one number of entries are concerned in the my lord, page 45.
Hmm.
So these 25 numbers entries were my lord, reported by once Subhas Bose, my lord. He was the then subdivisional engineer, page 65. His evidence matter. I'll just point out very quickly. My lord, whether this document I sought for, ledger book is the relevant one or it is not, because that 1996 5 474, the judgment has been placed. That favors me at that point.
Okay.
My endeavor is that this is the ledger book is the my lord, material document. So for this inquiry is concerned, because these entries are my lord, this list report has been prepared on the basis of the ledger. Kindly see his evidence on page 65. Second para, accordingly, sometime in this June 2008, I went to
Second
look.
para.
Second. Page 65. and look into the papers. I took look into the industrial ledger and ledger related to SPS. I submitted a report. This is the report with a copy of senior manager calling Psalm 21 NMLA. Now, my lord, prospered kindly similar. I checked the ledger. Proceed from my lord.
Hmm.
I checked the ledger both in the receipt from the
I checked the
computer.
ledger twice, once at instance of the senior manager,
Yes.
again at instance of GM.
Yes, yes. Then my lord, next slide. I checked the ledger both into the receipt issued from the computer and also the receipt issued by hand. My lord, therefore, what has been done so far as 21 entries are concerned, these are on the page, has been my lord, prepared on the page of the ledger. So, is my endeavor is my submission is that I prayed for the document for supply of the document page 28. Consumer ledger and subsidiary cash book, page 28, my lord. This is the communication by which, my lord, I pray before the authority, keep it is copy before submission of the written statement, they have not. In fact, in the
Just a minute,
inquiry,
just a minute.
Right.
Now, suppose you say that these are not available. Now, whether these were part of the evidence, that ledger and received 12,000. Finally, come to page 28.
my lord, please.
I have the honor to inform you, I have received a letter under reference and attend your official remand, but the document related to realization of energy bill as LS false receipt.
The number
Uh,
could
n-
not check due to non-ability of the consumer.
could not check due to non-ability of consumer ledger
Right.
and subsidiary case book at your office. Also, documents regarding receipt of 12,000, forget
Hmm.
about 12,000 is gone.
So I request you to afford me opportunity for inspection of the document technicality. Lord, this inspection never take place. My lord, here is the letter. They say that you go there. In their affidavit, they mention one meter, a reference of a letter that I have already mentioned in paragraph number 5. That is very important. Paragraph
Just a
5.
minute. Which one is it? Which one the exhibit 7? Record is there?
No.
How do you know that? What is the exhibit
My lord,
7?
perhaps the inspection report is page 25, 21 entries. These are from the my lord letter. They have-
What is exhibit 7? Because whole thing is based on this report.
Yes. And this report,
Where is the SARS memo?
Inspection report is part of the affidavit in office.
No, that we understand, but where is the SARS memo?
under the statement of investment.
Huh?
25.
Where is the list of document?
List of documents, my lord, page 27. My lord, these are the letters in respect of allegation of unauthorized effect. These are not the ledger book and all. But-
Where do we go get this? How these charges are proved? this misappropriation on the basis of some report.
Yes.
What is that exhibit 7? Is a part of your affidavit.
It's part of the
Just see it.
page 16 of our
Page 16. Laser was exhibited as
Exhibit 7, my lord, kindly see date from page 65.
that is the
Exhibit
same
7,
thing,
28/6.
same thing.
And my lord, page
21 entries, 21 entries.
Page 27, my lord. Document number 2, 28/6/2008. This is the
Page
report.
Page 27.
Yes, my lord. Second document. Document number
Page,
2,
page.
27. Yes. List
Just
of
a minute,
documents.
just a minute, just a minute.
Right.
There is no page 27.
Oh, my lord. In the repetition, my lord.
In repetition?
Yes.
Okay.
Sorry.
Yes, page 27
27, my lord.
is managers one. Where do we get that?
Accounts office, my lord. The second document.
No, where do we get these two documents?
Now, my lord,
These were exhibited as?
Exhibit 7. My lord, page 65, kindly see the
Okay,
evidence.
Page 67, page
65. 65 this is the evidence, my lord, of divisional, subdivisional engineer Golok Ganj, my lord. And he said, exhibit 7, lawsuit found, my lord, third paragraph.
report dated. Exhibit 7 is my report dated 26.
28/6, my lord.
Where is that? Okay,
28/6,
this is exhibit
2008
7.
is the
Okay.
report.
Okay, what is the witness number?
Witness number, management witness number 2, my lord. The top
Page,
of top.
page 65.
Yes. So therefore, my lord, unka harmful
Where is the exhibit 7 page?
page 16 of the affidavit, ma'am.
Then running page? Just a minute, page 16, na?
Yes. It-
Page 16 of your affidavit.
affidavit.
That's- Okay.
And page 18, my lord,
Mm-hmm.
is the
And where is that
letter of
letter? The 11,
Yes,
7,
yes.
11, 7,
page
page
18 of the
80. 18.
18.
Okay. Where is this witness?
Senior
This
manager,
is senior manager.
my lord, witness number 1. Police Control.
Witness number 1. Na? Where is his statement?
Page 63. Sorry. And here about the meter.
No, his case is he is not for misappropriation.
For
He is for
another.
another.
Yeah.
Two parts. One is the accounts who has verified the ledger and
Correct.
submitted a report.
As far as my lord, the inspection of the records goes, in our affidavit, my lord. At para 8 of our affidavit,
Any value debit?
yes, ma'am. It's important in the sense that we have categorically stated that he inspected the records on 24/11/2008 and 29/11/2008, and he inspected the records. Now, in reply, he does not deny. So he is admitted to this. His reply to our para 8,
No, no, forget about it. Forget that. Forget about it. Now, if you go by your argument of perversity, it's a finding of misappropriation. Misappropriation is based on a report. Report is Exhibit 7. Okay, what does the report say? Report reflects the conclusion, not the letter. His satisfaction that there is misappropriation. On the basis of his reading that this is misappropriation. Okay, and what is his evidence?
since the page,
Forget about other thing for a time. His evidence is at page 65. So that is his finding. Okay. Now see his cross examination. In his CF examination, in his CF, he says, I went there, verified the ledger, and I submitted a report. That his report is correct. On what basis that need to be, what should be the evidence that this is his report is correct? Should be the ledger that he has not misread. Now what is his evidence? He said as it is, I have verified the ledger and this is. For a moment, okay, we are saying that ledger may not be necessary for the time being because you have not relied upon the ledger itself. Your whole case is on report. Now, will it mean that proof of report is the proof that there is anomalies in ledger?
the report otherwise is gone out of the ledger itself.
No, understand. So there must be, according to a presumption, that whatever he has done is correct. Okay, we assume for a time. What is his evidence?
If he, my lord, looks at his cross examination,
The computer receipts were compared with the ledger with the help of an assistant outsourced.
Outsourced person.
No, maybe outsourced. We are not doubting outsourced. The cashier wrote both the subsidiary and main case. So it's relating to ledger. There is only one cashier in that office. From a copy of the subsidiary case book on 27 shown to me, it appears that cashier did not sign it. If there is a mistake in the computer generated receipt, the cashier cancels it. Now, from this evidence, how do you know that this is him who has manipulated the ledger or who has misapproved?
my lord, the report has been issued, given by the management witness number 1.
Ah,
His evidence is at page 60.
okay.
Subhash Ghosh
Hmm.
is the one, is management witness number 2.
Yes, that is what we are reading.
His evidence otherwise, my lord, because he, in his evidence, my lord, was pointing out what he has said in it. Page 63, my lord.
Page 63. Page 63 is of Kulesh Chandra.
No, it is Kulesh Chandra Sharma is the
Management
One.
witness one.
One.
Now, management witness two, who has prepared the report, who has brought on report exhibit 7. My question is, exhibit 7 is an extract of a actual fact. This is not the actual fact. Is it not perverse? What is perverse? This is case of no evidence. Your judgment supports.
No, my lord, that report.
Hmm.
is
Yes,
en-
come to the report.
Yes, the report otherwise is endorsed by two individuals.
No, understand. There is no quarrel on that.
Because the evidences of those two
No,
witnesses also has to be taken.
just satisfy us. A report, its report is a summary. He goes into the document, sees the ledger, and says that these are the anomaly. Okay, this is one aspect of the anomaly. And that anomaly is done by this person is another aspect. Your allegation is that you have misappropriated. Where is that?
The report
Hmm.
question.
Hmm.
It is prepared by the senior manager and
Hmm.
also endorsed by the account officer.
Hmm.
He is also a witness to the process.
Hmm.
Now his evidence also, my lord, will kindly.
Kulesh Sharma.
No, my lord, Subhas Ghosh.
Subhas Ghosh, you have seen it. I have read it 3 times.
Yes.
In the mean.
Now,
See, Mr. Gogoi, to our limited understanding, your allegation is that misappropriation of this app. Okay?
Yes.
By whom? By this person. So there must be, we are not reappreciating the evidence. We want that there must be something on record to show that there was some entrustments or it is his role to make entry into the ledger. Okay? And that he was entrusted with the money. Your whole allegation is on the basis of Exhibit 7. What is Exhibit 7? Exhibit 7 is a report which says there are some anomalies in the entry in the ledger. We agree to that. Now, what he says, who makes this entry into the ledger? The cashier. He is not the cashier.
my lord,
Something.
this evidence of my lord Subhas Ghosh.
Hmm.
Thereafter, my lord, there is an evidence
Because
of
whole thing is on the basis of
Yes.
his report. He has examined the ledger.
management witness number 3,
Hmm.
page 67,
Page 67.
PC.com.
Okay.
Now,
Page 67.
this is important now.
Hmm.
Now, it is, he has dealt with both the charges, issue with regard to unauthorized absence as well as anomalies in the register.
See next page. You come to page 65.
60,
Page 65.
68, 7.
No, just 60. We will conclude past 60. This Subhas.
My lord.
I did not mention anything about the involvement of the CEO in the anomalies reported by me. In fact, I did not mention any name as I did not examine this aspect causing the person responsible.
He's the account officer. He's the one who endorsed the inquiry.
Hmm.
Now, thereafter, my page 67
Hmm.
is the third management,
Hmm.
who is the he's the SD. He's the authority in that very subdivisional entity. His evidence, my lord, perhaps will be important.
Hmm.
Exhibit 10 onwards, I found some anomalies in the accounts involving the charge officer. As JE, among other duties, the CEO took after industrial billing. He had to raise industrial bills and also need to make ledger entries in the respect of the bill. He also used to raise bills in respect of SPPS and made ledger entries in the respect of bill. I found some anomalies in respect of industrial billing and informed the SM about this. He, along with the accounts officer of his office, visited the SD office and scrutinized the accounts. I also helped them. There were other allegations also against the charge officer in a village when so. My predecessor in office has learned by me, borrowed a transfer from so and so, perhaps not his profit. Yes. Accordingly, some consumers, page 16.
Hmm.
Accordingly, some consumers deposited the money and the then ST were
But you read prior to that.
Yes.
Why this situation arose?
on 26/2/2008. The charge officer wrote to me that about 50 applications for the ST were pending with me and ST is service connect. And requested
That
me
is
to-
a specific stand in the written statement.
I
And
asked
he
him
has
in-
agreed during cross examination.
I asked him in writing to put up the matter in file. My predecessor in office released some service connection in villages Kursa Katkoti and Mulon Dubi without formally issuing receipts. Entries were made in the ledger also, but the consumers did not pay the bill rate. I held a discussion with the concerned village on 11/12/2007 on this. I reported the matter to the CTM with copies to the other. In the meeting held on 11/12/2007, it was decided that the consumer would pay 2,300, including so and regularize the matter. Accordingly, some consumers deposited the money and then service connections were regularized. Rupees 850 was deposited in the office in the cashier. The balance amount was used for processing a meter and having it tested. I did not handle cash. It was handled by a team consisting of the SDE, JE is the petitioner method, and lineman and Sahayak under my instruction. I remember a case involving so and so. Then page 70, the irregularities mentioned in page 1-2, where during the period the charge officer was in charge of the industrial billing, the ledger entries are in the handwriting of the charge.
Who is the ledger?
Ledger malus was
It is the fundamental thing.
he's inspected the record. The documents he's got for are not separate to the case.
No,
in
no,
hand.
forget about his
Yes.
document. We are not saying about him. He is not getting a copy of the ledger. It is not your document even. That is the where our anxiety is.
Document otherwise malus has been proved.
What document is proof?
By the
Ledger is proof that this
It
has
is
been
drawn
done
from the
by.
ledger.
Where is the ledger? Everybody is saying ledger is manipulated by him. Where is the ledger? The inquiry, who has inspected the ledger? He says, I know nothing. I have seen these are the anomalies. Who has done? Who has not done nothing? Some other officer says ledger was done by him. He ought to have shown to him that this is your signature. Will not say that you need a forensic report in a departmental proceeding. At
But
least,
It is based on evidence.
Huh?
Definitely based on evidence. There is a report. Report is based on the findings. of the-
report is not a report is based on a ledger. So you want to say once a report is given, it has have the sanctity by an officer. He himself says that I have just seen it and prepared it. Who has done it? Who has not?
No,
And I am not aware.
The other officer who endorses that.
He
very
says-
report,
He says
categorically says.
he categorically says the
And
ledger
the-
is being done by him.
Yes.
But where is the ledger to?
And the
at least-
authority under. whom
Is
he
it
was
not
working-
is it not a necessary justice for him to see that those you are saying that I have written it? Show me that ledger. I will cross-examine. This is not my signature. This is not my handwriting. Where is Is it not a natural justice?
Now that report otherwise, Matlab, the authority under whom he was working, the SD also goes on to prove that document. He says, he confirms the anomalies. He says that he was the one dealing with cash. The entries were made by him.
It
And
is
it
like
is his
that.
handwriting.
So you want to say that this is an evidence,
But this evidence perhaps is not to the highest possible level, but there is
not
evidence.
highest, this is not highest possible, this is no evidence.
There is evidence. Matlab,
This is
perhaps.
no evidence. The exhibit 7 is no evidence. Because see, think of your allegation. That Mr. So, you have taken this money without receipt. Okay? And these findings we have come on the basis of ledger. So whole foundation is your ledger. And you say that you have entered. Admittedly, he is not the case here. But some officers say he has done it. Okay, fine, he has done it. At least ledger should be there. He should have an opportunity to say that this is not my signature. Or I have not done it. Anything and everything, exhibiting a document is not a evidence, always. The judgments we are aware that when it is a case of no evidence or a reasonable person would not have arrived at a conclusion on the basis of the evidence. Okay. Now, what are here evidence? Forget about the not proving of the receipt or false receipt. Forget about that. That nobody will insist. You came to a conclusion on the basis of a ledger, not on the basis of an inquiry. Inquiry report is a summarization of the ledger. So if we go and by your argument, then we will have to presume that the report is sacrosanct. The officer cannot do mistake. Whereas the person who has prepared the report says, I have not seen who was supposed to do, who has not done.
Two people
That
have
part is
prepared
good.
it.
That part
Two
is
people
good.
have prepared it. Matlab,
Okay.
one said-
The other person says that he has done it. From where? From the ledger. From the ledger. He's not been shown the ledger.
On that point, perhaps I'll have to dig a little deeper.
Huh?
On judgment. Whether this will be enough.
Hmm?
As evidence. Matlab, as quality
No,
or
what is the evidence? We want to
Yes.
know that.
if this would amount to evidence, that would be clinching.
Huh.
That would
Not
be-
even clinching. That you have a satisfaction. Reasonable man will have a satisfaction.
Witnesses have come forward, stated that he's done it.
Understand?
He's indulged in these
So
things.
therefore, if we uphold your contention, a situation will come where we will say that whatever management says is evidence, and therefore, once there is an evidence that it cannot be perfect. Even whatever they say, document may something else, but since they are witnesses, in absence of document, whatever it says should be treated as the document itself. This is basic fundamental. We are not insisting on evidence, even preponderance of probability like civil case. Not to say about beyond reasonable. But where is the foundation? Okay, you have laid the foundation. Fine. But where is the scope for him to rebut that evidence?
So,
I say, I have seen the ledger. From the ledger, I have seen that this is the man. So your evidence is sacrosanct. There is evidence. So a reliable person can conclude his statement is truth, but nothing but truth. So whatever he says actually is in the ledger. Even he need not have a chance to rebut this. Is it an evidence? When? CAB or you want to think over it?
perhaps the records might be. I'll try and endeavor to get the record. That would
You tried hard. That's why we want to give you a chance. Otherwise,
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 one charge has been proved, man. He's
that is a different issue.
admitted, in fact.
That part will deal with it in a way. His argument is it is not proved that willful.
Because Sarge itself says that he submitted application. If he has intimated.
We are on this money because this is public money. Forget about in unauthorized absence. You can increment this, that. You can understand. But this is a public money. We do not want to, if he has done it, but public money, 91,000 at that point of time was a huge. But what to do? You thought we are the office.
Ultimately, that is 37,000.
We are the officers. We have our record. Our efficient officer has prepared a record. So that has become sacrosanct. Who is he to cross-examine? Then,
Still, my lord, I'll try and set it
then
right.
there would not have been any necessity to give a chance to cross-examine. Isn't it? That is the principles of natural justice. We are not saying that it should be like a criminal. When
Which time?
part in part, please, better for further. We'll start the dictating the facts.
Yes, sir.
Not today, but today, otherwise you would have dictated your arguments and facts. 29.
Deeply.
Just think over it.
Yes.
We know that we cannot reappreciate evidence. Number one. Number two, only in case of perversity, we can. What is a perversity?
Whether or not this-
Either no evidence or misreading of evidence also can be a perversity. Sun rises in the east, you say sun rises in the west. You said it, that sun rises, but it's perverse. So that angle is
I'll try and also get that. Deeply.
yes. What is this?
Yes, my lord. My lord, it's there are people in the district.
Hmm.
My lord, are the matter partially and given the partiality in the matter of conduct, review DPC and
So review DPC is done.
still cover procedure to be followed.
Hmm.
That is my another prayer because he was under cloud. So these circumstances with reference to KV Janaki Raman, still cover procedure followed, and that part is over.
Hmm.
Now, I draw my lord's attention to page.
Which
8.
repetition we are taking up?
My lord, I am taking up the 8708.
And what about 870? Okay, what
Yeah,
is this
it is
IA?
bifurcated now.
What is this IA?
IA means those who if somebody is made junior because of his promotion, so I have made that IA was filed, but the promotional issue is over, my
What is under challenge here?
a grant of non-functional office. I draw my lord's attention to the prayer part, page 18. I'll read the prayer for my lord's convenience. My lord, I read page 18, Roman 2,
Just a
because
minute.
Roman 1 is not.
Just a
that-
minute. First part is order dated 20.
25th April 20. My lord has passed out.
No. This is first prayer was to set aside
My lord, to set aside that Government of India Ministry of Defense Border Development Year 2
28th
G1
of February
order
2019. Where is that?
pertaining to promotion order of superintendent engineer
Page
to chief
42.
superintendent engineer
Yes,
to chief engineer.
Page 42.
my lord, it is the page 42, my lord. This I am not submitting before my lord because that DPC has been considered by lord on 25th of April 22. So
And
that part
that
is
has
over.
been, they have
They have
considered.
put him in the silk
Silk.
as per my lord director. Now I am coming to my lord in the second part, Roman 2,
Then where is that 9th March order? Where is the page?
9th March order. Yes,
Page,
page 9th March. My lord, it is the order of the I just bring the order, my lord. Page 42, Annexure 6. Before that, I beg to explain to my lord the concept of NAQ. Give permission.
concept of
NAQ, non-functional upgrade. That is, my lord, annexure. That concept has been built upon, my lord, in page 36, annexure 5. And most importantly, my lord, page 41 is very important to shorten the
page.
41 because they have exemplified what is the NAQ concept.
Why this matter is here? This is IS officer.
No matter what is happening, madam. NAQ, non-functional upgradation, the center has got no IS officer as such posted. So state of the joint cadre officers are deputed to center from the rank of undersecretary to the, it can be additional secretary and secretary also. So the organized service officer who are senior by 2 years to those IS officers who are deputed to center in a particular post are also to be given that same scale. Now I read, my lord, for my lord information. If officer of 87 batch of IS are empaneled as joint secretary in the grade pay of 10,000, PB4 an officer of the batch gets posted in the center under central staffing scheme. They are on central deputy. On 15 January 8, all the officer 98 batch of organized group A central service. Well, organized group A means that there should be a post of joint secretary. That is of 10,000 care. And then the cadre become organized. Since officer of 85 batch of organized group A central services who have not been promoted to the joint secretary.
Okay, tell your facts. Tell your facts now. That we understood.
Yes, my lord.
Tell your
So
facts.
now, what is the issue is that, my lord, as my lord directed that this, what is the date of he is entitled for NAQ with effect from 1st April 2004. As per the order that I have read.
No, why? Tell us first. When have you appointed? When the others are given?
Yes, my
These
lord.
are the important facts. If you
Yes,
go
my
by
lord. Yes, my
yes,
lord.
isn't it?
Yes, my lord. Yes.
What was your rank?
Yes,
How
my
you
lord,
enter into?
Yes. My lord, I am a superintendent engineer, presently working and after I was in Dimapur. So basically I was under cloud and that's why my DPC for the promotion to the rank of chief engineer was not done and was not put in the seal cover as per my lord director. They have put the seal cover. My lord, now the question is, as far as the DPC is concerned, since I was on the cloud, they have put me under seal cover.
What happened to DPC?
DPC it is they have put me in the seal cover procedure, and I think they have they might have some processes going on. I am not concerned about that.
That is the incorrect fact.
Hmm.
It's the incorrect fact.
What
No
happened?
seal cover.
was there. In fact, he was not within the zone of consideration itself because it's not fulfilled its eligibility criteria for promotion. He was not within the zone of consideration. So that's why his case was not.
Now, let I'll come to the tell you that is my core issue. What
No,
is
no, no, we'll go to that.
Okay.
You want non-functional
upgrading?
upgrades.
Yes, ma'am.
Now,
And what is the
whether,
keyword for
what
that?
is the reason of non-giving according to you this non-functional upgrade?
Yes,
First, tell us why you
I-
have not been given.
yes, ma'am. First, they say I am not eligible for non-functional upgradation because as per the recruitment and promotion rule 1988,
Hmm.
there is a mandatory requirement of 2 year command tenure.
Okay,
Command tenure meaning may not be if the project stage food is located, there is a one task force that is the Tanga Valley,
Hmm.
14 task force. So somebody is heading the 14 task force that is known as command tenure.
Hmm.
What happened, my lord? I have done the tenure for 1 year 6 months on being promoted to the rank of superintendent engineer.
Hmm.
So I am trying to be achieving the rank of chief engineer.
no,
So-
come to the facts later on. First thing is
uh,
that your case is
Yes,
rejected
command tenure. So I am
on the ground of non-having command.
command
tenure.
tenure. part.
Okay, and secondly,
as per the
whether you are DR or not, it's a second stage.
second.
Let us understand. Then,
Second, my lord.
what
As
second
per-
reason?
As per because they say as per the respondent statement that criminal case was going.
Okay, so first part is command training.
Command tenure I have not completed.
Second,
Second, is as per their statement, the criminal case was going.
okay.
And I am
Now, what is the
eligible-
status of the criminal case?
Huh?
What is-
Status of the criminal case, my lord, that was taken cognizance of 2018.
No, what is the present status?
Present status, it is going on, my lord.
Charge is frame.
The charges pen and taking
Evidence-
cognizance also.
It is in evidence.
Evidence
So criminal case is going on.
Going on,
First is command, second is criminal.
yes.
Now,
3rd of December 18, it was taken cognizance.
no, forget about that. That is not important for the time being. We'll go
Yes, ma'am.
details. And
Now,
what is the other reason?
there is no other reason.
Now,
Whether
Are they permitted to not to grant functional upgradation in absence of command training and
yes, my lord.
tendency of criminal?
That's why I'll draw my lord's attention
Hmm.
the DOP what
Hmm.
the guidelines say
Hmm.
in this subject matter. I've got 2 line of argument in the subject matter.
No, argument later on.
Ah.
Understanding is the first.
Okay, my
Yes.
I bow down and
Ah.
submit, my lord. That is the page 9 of my report. I read the last paragraph. It is the DOPT guideline dated 25th March 96, my lord. I read the last paragraph that important to me, my lord. Where juniors who have completed their qualifying eligible services are being considered for promotion. Their seniors would also be considered provided they are not short of the requisite qualifying eligibility service by more than half such qualifying eligibility service or whichever is less and have successfully completed their probation period for promotion to the next higher grade along with the juniors who have already completed such qualifying eligible service.
Okay.
So my lord, now to consider whether where he stands, I have to
Where is your command posting?
my lord?
Command posting.
That was in Firmu. That was 760 BRT.
Where do
That-
you get that?
That my lord, I
Now let us know see where is their power to not to give this upgradation on the basis of criminal proceeding. Where is that?
that is first I am not yet finished. my lord.
Yes.
So, my lord, I just beg to submit that he's standing in the seniority. Then my lord will understand how the junior has been promoted. My lord, I draw my lord's attention, page 29.
Yes.
And in 29, 10 number, the petitioner stands.
Yes.
My lord, 10 number. Now 11 number is Ravindra Kumar Saha and 12th is Jitendra Prasad.
Hmm.
So, my lord, because he being senior to both of. Now, how I can judge that they have got NFU? Now I draw my lord's attention to page 42 to justify that petitioner has been superseded for the grant of NFU.
Where is Rabindra and Jiten?
My lord, number 1 is Jitendra Prasad,
Hmm.
1414, my lord,
Jiten.
and 1414.
And Rabindra?
Ravindra, my lord, his name is not there. He has got some disciplinary case pending.
Okay.
So, Jitendra Prasad, though next to the petitioner, third in serial being serial number 12, he was granted non-functional upgradation
2016.
from 1st April 2014. The order
No,
was passed on
Jitendra was granted on 1/4/2014 and Rabindra was granted on 1/4/2016.
Ravindra Prasad was granted subsequently. my lord.
1/4/2016, I know that.
Aha,
Yes.
yes.
Yes. Then
Acha, my lord, what happened?
Hmm.
So my contention that if the junior is promoted, senior to be considered with reference to 1986 late. So that letter says
half
that-
or 2 years.
half or 12. So I have completed my 1 year, 6 months tenure. It is their admission only in the counter debate. I'll come to the counter debate
Hmm.
also.
Hmm.
So now issue is that
When have you completed this 1.5?
my
Late.
lord, that is I completed my lord. That is I was there from August 2011 to 19 March 2013.
So prior to their promotion. Prior to prior to granting your juniors the
I have already
benefit.
completed. I have completed more than 1 year, 6 months, my lord, 28 days.
Hmm.
In fact,
Now,
now, my lord, what happens? The grant, if the junior is promoted, senior to be considered, it cannot be automatic.
Hmm.
There should be amendment of the recruitment and promotion rule. So I'll draw my lord's attention to various categories where recruitment and promotion rule has been amended, and that is the reason Justice Honorable Justice Sanjay Medhi sir has directed on 23/6/22, my lord. I read, Mr. T. Das, Learned Counsel for the petitioner, whereas the respondents are represented by RK.
do not read all the unnecessary things. Come to the point.
Appoint me.
Why you need to read hard
yes, my
so
lord.
and so.
So, my humble submission, my lord,
Hmm.
in 1988, my recruitment promotion was there
Hmm.
for the civilian.
Hmm.
Since then, there is no amendment made
Hmm.
incorporating this para of 1986 of the QFT. Now, I'll show my lord where the amendment has been made, in what are the cases the amendment has been made, my lord.
Now,
Now,
no. Why is the amendment relevant now?
my lord, if there is no, they say,
Till date, there is no amendment.
no, my lord.
So
That
you
is
want-
the instruction was given.
So there
Direction
is,
given.
see, there was no amendment. So according to you, the notification issued, therefore is not applicable, cannot be made applicable in absence of amendment. According to you.
No, my lord. What it is, this is the one first line of thought. My argument is that so they have not made amendment that isn't known to them, but they have amended even the senior cadre, additional director general border. That is the next upper
Now
cadre
what-
of chief engineer. I'll show, my lord.
No, understand. We accept it that
Yes.
there is no amendment.
They have not made the
So if there is no amendment, do you propose to say that since there is no amendment, no right has been created in my favor.
My lord, if there is no amendment, then I should not suffer for that, my lord.
Understand? Let me, so if there is no amendment, no right has been created. Now what the read code can do?
Right.
Tell us that.
So, right, my lord, this, now I'll show where they have made amendment.
No, no. I
all
accept everything. They have done amendment everywhere, but they have not done amendment so far relating to the case of people like you. That is, when junior is promoted to the next higher grade,
Yes, my lord.
those next higher grade where disqualification they have not attained. However, there is an executive instruction.
Yes, my lord.
Isn't it?
Yes, my lord.
Now you say that there is no amendment.
Yes, my
Now,
lord.
do you propose to say that we should pass a direction to make an amendment?
My lord, that because
No, no, not because. This is answer the question.
This is NFU is the beneficial proposition.
No, no, understand. Do you
Like
propose
SCP, MSCP.
that should be the reason. If we have a power to ask for amendment, that should be the reason. Do you propose to say that a writ should be issued to amend the?
I humbly bow down and accept my lord's view. Now I come to the second line of argument.
So therefore, it cannot be amended. There cannot be no writ can be issued to make an amendment.
So I now come to the second
Okay,
line of
so
argument.
that
my
part
lord.
is gone.
Uh,
What is
second-
it? What is second line?
Second line of argument.
Yes.
Well, I draw my lord's attention. Now there is the QPT order also, my lord,
Hmm.
2011. That order said that if a superintendent engineer
Hmm.
having 17 years of service
Hmm.
and out of 17 years, 1 year in the superintendent engineer cadre
Hmm.
is eligible for promotion.
Okay.
How Jitendra Prasad has been done,
Hmm.
then I have submitted before my lord that Jitendra Prasad was junior to Mr. Ramila.
Hmm.
So how Jitendra Prasad has been promoted, then I have to draw my lord's attention to the RNP rule
Hmm.
so that my lord can correlate things. So RNP rule has been given, my lord. This is the page, page 22, my lord. Page 22, I think, my lord. Chief engineer, my lord, at the top below. This is the page 22, 17. Chief engineer, brigadier C, PRES, civil cadre.
Yes.
Right, madam?
Yes.
So I come to column 12,
Page 22.
page 20.
Schedule.
Column 12, promotion.
Yes.
Heading is from.
Hmm.
Borders engineering service officer only, superintendent engineer with 8 years regular service in the grade, including service depending in the non-functional selection grade, or 17 years regular service in group A of Borders engineering service, out of which 4 years in the grade of superintendent engineer. The officer should also have 2 years as task force commander. Right, madam?
Hmm.
So they say 4 years should be as superintendent engineer. Out of 4 years, 2 years should be task force commander. But let us come to the Jitendra Prasad. When here, what is the seniority? Now I draw my lord's attention to page.
No, no. So out of this, are you having all this qualification?
Yes, I am having the qualification.
Okay. Admitted for a time being, you are having this qualification for promotion to the next higher grade of
Chief engineer.
chief engineer.
Yes.
Now,
There-
how many posts for chief engineer are there?
My lord, this is not a promotional issue. Non-functional upgradation is nothing to do with the post. It is whenever an IS cadre officer is deputed to center,
Hmm.
organized service officer who are senior to them by 2 years are entitled to get the scale only. It is a non-functional in nature. It is
Yeah.
a beneficial like SCP, MSCP, my lord.
Okay.
So it does not relate with the vacancy.
Hmm.
That is why I submitted the implement application is non-functional here also.
So so according to you, they have not considered for want of command.
One top command.
and one pendency of criminal case. So
No,
as where is their power to stop for criminal process?
My lord, criminal case, now pendency of criminal case.
Ah.
The criminal case, as per their affidavit, my lord,
Mm.
I read from their affidavit.
Mm.
I draw my lord's attention to page. I read, my lord, for a
Mm.
moment.
Mm.
The prosecution sanction has already been accorded by the department by
No,
secretary.
no, we do not want that fact. We want where is the power or source of power which says in case of a pendency of a criminal case, a person's promotion or NFU should
Yes.
not be granted.
But I was eligible for non-function on
So,
1st April, my lord,
Mm.
2004.
Mm.
Criminal case taken cognizance in 2018, my lord.
Mm.
Before that, High Court also squashed the CBI, closed the case. Then it was revived. High Court stayed it. Then now recently on 18 also this has taken into cognizance. What the GOPT says, my lord, for a moment I read about the GOPT guidelines on the criminal case.
Based
My lord, GOPT says it the charge sheet, the criminal case to be taken into is to be taken into cognizance, and then from that day only the officer of any subordinate will be under class.
so as that. Based.
My lord, I'm just right.
Where is Mr. Gupta? Where is that?
What?
Uh,
Let him complete, my lord.
My lord, this is the PSC. PSC 8B, my GOPT guidance.
Okay.
So, my lord, as per their submission, my lord, basically, I did for a moment my lord's information. However, the trial was stayed by the Honorable Guwahati High Court order dated, that is, I'm reading from page 4 of the complaint. Repeat. High Court order 16/6/15 in criminal division petition C4115 filed by the petitioner. The stay was vacated by the Honorable Guwahati High Court order dated 18/28/4/17, my lord.
Mm.
Page 4, my lord.
You read
Okay.
it. You read it.
The charge sheet filed before the learned special judge CBI additional court Jadmari Guwahati on 29/8/18 and trial before the court is still under progress and the next date of hearing is fixed for necessary order 5/20. And the same was taken cognizance, my lord, that is on 3/12/18.
Mm.
It is they have stated. So, my lord, on 1st April,
Mm.
1st April, there was no criminal case pending because
Mm.
NFU guidelines of 2009, it says also methodology for selection.
Take your seat. Yes, Mr. Gupta.
My lord, I just want to highlight the 46.
Take your seat for a time.
My lord, at the outset, I would like to submit that, my lord, the petitioner was never within the zone of consideration. He was not within the zone of consideration for the post of promotion,
You are
the post of
superintendent.
chief engineer
engineer.
from superintendent engineer.
What is the criteria?
The rule, my lord, just now was referred at page 22
Hmm.
of the petition, if I may read, my lord.
Hmm.
Which says, my lord, that the border road engineering officers only, and start from superintending engineer civil with 8 years of regular service in the grade, including services
Just a minute, page 22,
page 22, my lord. Column 12. Let me start with superintending engineer civil with
page
8,
20, serial,
column number 12, my lord, which deals with the criteria.
page 22, okay?
Column 12, my lord, 10, 11, and then 12, my lord, the
mm.
middle, my lord.
Mm.
Superintending engineer with 8 years regular
Just
service.
a minute. Uh, Superintendent engineering
Civil.
civil with 8 years regular service in the grade.
Grade, including service if any in the non-functional grade, or 17 years regular service in group A of border road engineering service. Now this is not civil. From here it is not important. Note, out of which 4 years should be in the grade of superintending engineer, comma, the officer should also have had 2 years experience as task force commander in the rank of superintending engineer in order to be eligible for promotion. So, my lord, when the petitioner was holding the charge of superintending engineer
Mm.
with the additional, my lord, that in the he was in the rank of superintending engineer civil, and
Now
he was
tell us,
also, my lord,
tell us when he was promoted to the rank of superintendent engineer.
my lord,
But he was promoted to the rank of superintendent engineer on 11th April.
These are the vital facts for
11th
determination.
April 2011.
Instead of going to what the rule says.
11th April 2011.
so therefore, my lord,
Just
when-
a minute,
No.
just a minute, just. 26/8/2011.
Yes.
Is that it?
If when he continued to come up after his ultimate new
Yes,
rank of
26/8/11.
26 August 2011.
That is what I'm saying. Then
So, my lord, a superintending engineer civil should have the 2 years experience as a task force commander.
no,
my lord.
up to 2011, when the other person was promoted to the superintendent engineer,
My lord,
his
that is
junior.
2018, my lord. What was referred to by the petitioner, my lord, the order that is of
Okay,
2018.
to 26/8/2011. Fine.
No, that is subsequently, my lord. The petitioner's case is prior to that. Page 42, my lord, which has been referred, my lord.
No,
That
no,
is
just a
pertaining
minute,
to
just let us understand.
2016.
Now, task force, when we are in task force,
He was
22 August 2011.
22,
August 2011.
where he was posted?
My lord, in 763 BRTF.
my lord, in fact,
And,
Just
my
a minute, just a minute. Just you take note of his dates, then rebut it. Yes, when?
and my lord, 22
When
August,
he was to command put
22 August 2011, my lord.
22 August 2011,
11.
he was posted
As
task force.
task force commander, my lord.
Where?
My lord, at 763 BRTF. Correct.
Till
Till, my lord, 20 March 2013, my lord, when he was apprehended by CPI.
28th of
March
March
2013. He was
2013.
suspended, my lord, on that date itself.
So he's having, okay.
1 year, 6 months, my lord. He is not fulfilling that criteria of 2 years. Therefore, my lord, he was not in the zone of consideration itself. That is why his case was not considered, and as on
Now,
date,
in the task force,
No.
he was still,
20 March 2013, my lord, when he was suspended.
he was promoted to the superintendent engineer on 26/8/2011,
11.
while he was working as task force commander.
No, my lord. No, my lord.
Yes,
because
yes, because he was he was promoted on
officiating.
22/8/2011.
Let me come.
From
If your
11
facts are not clear
26
for you,
My lord, he
then
was
why
pro-
should we wasting time? People are waiting.
No, no.
according to you, he was posted as task force commander on 22nd of August 2011.
Yes,
And he was promoted to superintendent engineer on 26/8/2011.
yes, my lord.
So his uh, command will start, should be counted from 26/8/11 to 28th of March 2023.
Yes,
Isn't it?
My lord, my lord, after becoming superintending engineer only, my lord, he can hold the task. My lord, date, my lord, I
No,
think
no,
there is some
that is what I'm
confusion.
saying.
Like-
His task will be taken note of from 26/8/2011 when he was promoted.
Yes, yes, my lord.
Because it is the rank is not only task, it should be in the rank of super.
Yes, superintending
Yeah.
engineer.
So he was promoted to the superintendent engineer on the first time on 26th. Though he was in the task from 22nd, his
Yeah.
count will be 26 to 28th of March 2023.
So 13, my lord.
Huh?
2013.
13. 13 to 1.5 year.
My lord.
Okay.
1
so,
year, 6 months, my lord.
1 year, 6 months.
Yeah.
So according to you, since he is not having the 2 years, he cannot be promoted under the rule.
And even he cannot be granted NFU. Because NFU is granted only when a person is eligible for promotion. And the criteria for eligibility of promotion is
So
actually
NFU is granted.
applicable to-
NFU is granted when he becomes eligible for promotion, and if he is not eligible for promotion, then NFU is granted in lieu of promotion.
Yes, ma'am.
When he cannot be promoted,
Yes.
so that
So
is
the
your.
eligibility criteria has to be full.
Now, what do you say about that notification which says in case of senior is
Yes,
promoted
my-
so far NFU, he should be.
That we have dealt in paragraph 12 of
Don't
my.
forget about dealt in. I
affidavit
do
of
not
full-
like this dealt in
So
paragraph.
that is not applicable to them, my lord. We have stated that this criteria is not applicable to them, and the relaxation, my lord, is not of the 2 years criteria as task force commander, but the relaxation pertains to the total, my lord, qualifying.
Okay, let us
service.
see that notification. It's a
Qualifying, yes,
simple case. You are
Yes.
arguing how, what not. Yes, tell us.
qualifying service. The notification is, my lord, at page 30,
Show us the notification.
page 32 of the, my lord, 32 of the petition, my lord.
It's a general relaxation.
It's a general election. It talks
Ah.
about qualifying service.
Hmm.
Qualifying, where juniors have completed their qualifying service,
Hmm.
eligibility services are being considered for promotion. Their seniors would also be considered, provided that they are not short of requisite qualifying / eligibility service.
Hmm.
But
So
that relates to, my lord, the 8 years period and 17 years.
why not? Why not command?
So that is not related to command. That is, my lord,
Why not? Tell us.
my lord.
Can you distinction that it's a eligibility criteria? Command is also a eligibility criteria. So that a person at least gets a NFU when he's junior is because his command posting is at the discretion of your discretion.
I have
Some
applied also, my lord.
take your seat. Command post is your discretion.
My lord.
A person senior may not get, may get. So therefore, two part so far relating to the eligibility that is over. Now tell us about criminal case.
Criminal case,
When,
that is not
when
on the
in
ground.
terms of this 1.5 year, when he become entitled for NFU.
to this, my lord, my contention is that, my lord, he was not eligible at all as per the.
No, we have rejected
rule.
that. We have rejected that because of this memorandum. Memorandum says revision of guidelines for framing, amendment, relaxation of recruitment rules, consideration for senior in cases of juniors are considered.
So that is
And
not
that is- huh?
applicable, my lord. We have stated that this OM is not applicable, and the requirement of this task force cannot be relaxed, my lord, as per the recruitment rules. So this OM is not applicable to the petitioners. We have categorically stated in our affidavit, my lord. But this, in paragraph 12,
So you are not under the ministries. You don't have any ministry.
no, my lord. it is under the
You
recruitment
run
rules,
under whom? Independent.
my lord, but this guidelines is not applicable.
No,
because, my lord,
no, we understand this
No, no.
guidelines is applicable, not applicable. Your officer saying not applicable will not do. You'll have to give reason why not applicable.
Because, my lord, the recruitment rules cannot be relaxed, my lord.
But recruitment can be relaxed.
recruitment rules, my
Can
lord.
be relaxed. It itself says revision of who has issued this. Ministry of Personnel, PG and Pension. So we'll set aside this on the statement of ASG. And all promotional granted to all departments will be withdrawn.
Lord, under applicability, my lord, may I take a instruction in that case, my lord? Because. we
No, no,
will-
your officer will say, we are in the midst of hearing.
Yes.
An officer will saying that it will not be applicable, must be given some reason.
Mm.
Now see, it is issued by the Ministry of Personnel, PG and Pension.
No.
This is the controlling ministry so far relating to the service. Now come to the next page, all ministries, departments of Government of India. If you say you are not under any ministry,
My lord,
that is fine.
correct.
my lord, that
may-
is
Take your seat, please.
My lord, may take paragraph 12 of our reply, my lord, we have answered the affidavit in opposition.
What is your answer? Tell us.
If I may read from.
Don't read, tell us. What
Well,
is the reason that this is not applicable? Somebody will saying this is not applicable, will not be.
My lord, if I may, seek permission, my lord, will take up that paragraph, my lord.
Will not take, you read it.
My lord, I will read, may I read?
Hmm. If
The-
you cannot speak, then you read.
My lord. The dependent, my lord, further begs to state that the DOPT OM dated 25/3/1996 at para 1 states that service who have completed their probation period may also be considered for promotion when their juniors who have completed the requisite services are being considered. In border engineering service group A, probation period is applicable only at entry level in assistant executive engineer, and hence the relaxation given at paragraph 2 of the said OM is applicable only for promotion from AE civil to executive engineer civil, as there is no further probation period on being promoted to executive engineer civil and above. However, the petitioner, who is a very high-ranking officer in BRO, is attempting to put in the court, knowing the fact very well that there is no probation period at the level of executive engineer civil and above, and therefore relaxation sought by him under quoted OM dated 25/3/1996 for promotion to the post to chief engineer civil from superintendent civil without having the requisite qualifying eligibility criteria as per the recruitment and promotion rules is uncalled for and deceptive. Further, the contention of the petition in this paragraph that his juniors, namely Ravindra Kumar Saha and Jitendra Kumar Saha, have been promoted by reducing the task force command tenure to 1 year is denied, and hence the petition should produce documentary proof of conducting DPC for the panel year 18 and 19 in violation of the OM dated 25/3/1996. So, my lord, that this relaxation is not applicable for this particular post, only for the probationers it is applicable, my lord.
What do you mean by the probation period for promotion?
Because, my lord, in the case
What
of
is the, show me any rule where there you need a probation period for promotion. This probation means the qualifying period, that you must be 7 years in a,
it is in case of, my lord, only AE and when there is a promotion from the post of AE.
read, where juniors who have completed their qualifying eligibility service are being considered for promotion. Their senior would also be considered subject to what? They are not short of requisite qualifying eligible service by more than half of such qualifying eligible service or 2 years, whichever is less, and have successfully completed their probation period for promotion to the next higher grade, along with their juniors who have already completed such qualifying eligible service. So what do you mean by this probation?
Probation period, my lord.
What is the meaning of probation period for promotion? What is the dictionary meaning of probation?
Probation, my lord, immediately after the joining initial period is.
So where is the question of probation in a promotion? That language will have to interpret as a probation means the minimum period required for promotion to the next higher grade. Here, it is 7 years as a superintendent engineer.
No, my lord,
In addition, you need a special qualifying service of 2 years That
Here-
says if juniors, everybody is having 7 years. 7 years is a must. Probation period is a must. And the 2 years, in case of junior is appointed, you can relax to the half.
No.
Isn't it?
My lord, that is only at the entry level. my- If I may read again, my lord, the paragraph which I have read, my lord, in border engineering service group A, probation period is applicable only at
Where
entry
you
level.
affidavit.
Yes, my lord.
No, we want the first interpretation of this memorandum.
Yes, no, this memorandum is applicable, my lord,
To
only in respect of, my lord, and the probation period at
where
entry
do we
level,
get that from this memorandum?
my lord.
We are not bound by your officer statement.
No.
We are bound by this office memorandum. We are here to interpret the office
My lord, the-
memorandum,
sir.
not to interpret your officer statement.
No.
Your officer statements are not gospel truth. Tell us from this document where not applicable.
My lord, the word probation period is there, my lord.
So that's
Second
why I'm asking, what do you mean by probation
line.
period? Where is the question of promotion in a probation period?
That's what we have, stated in our affidavit, that probation period in the post of CE, my lord, there is no probation period applicable. Therefore, it is only for the post,
Probation period is applicable where?
for the post of assistant executive
When it is
engineer.
an entry level.
Yes. That is why this OM is not applicable. This OM is,
Where is the judgment of Prabhadevi? Yes, Mr. Prabhadevi's judgment.
My lord,
Prabhadevi's judgment.
my lord, in page 26, they have applied the rule in RNP rule in for chief engineer level. So when he says, my lord, that it is for entry level, it is wrong, my lord.
We'll
Just
stop,
for a moment.
we'll stop hearing lawyers and we'll do job in our chamber. Left.
My lord, just for a moment. My lord, page 30. Just for a moment, the last submission, my lord, page 31. He says that it is for entry level. I'll show that it is not for entry level, it is for chief engineer level also. And it is not for probationer. There is the probation period for gazetted officer, my lord. And accepting AEE to E for the border dose organization. My lord, I come 26, my lord. And this is even page 30, my lord.
Laptop or dongle.
Page 30, my lord.
Yes, read, whatever you like to read.
My lord, where juniors who have been there qualifying, page 30, where juniors who have completed their qualifying eligible service are being considered for promotion. Their seniors should also be considered provided they are not short of requisite qualifying eligibility service by more than half of such qualifying eligibility service or 2 years. Whichever is less and have successfully completed their probation period for promotion to the next higher grade along with the junior. This is for executive engineer, my lord. This now for the additional director general border roles also. They have complied with the order also, my lord. My lord, just for a moment, additional director general border is the next highest rank of the border organization, page 24, my lord. I did, my lord. Page
Read it.
Where juniors who have been completed their qualifying eligibility service are being considered for promotion. The seniors should also be considered provided they are not short of requisite qualifying eligibility service by more than half of such qualifying eligibility service or 2 years, whichever is less, and have successfully completed their probation period for promotion to the next higher grade along with the juniors who have already completed their qualifying service. So for the next top rank is director general border, next higher rank is additional director general border. In his submission that it is applicable for assistant executive engineer to executive engineer stands on wrong premise. That is my humble submission.
1982 SCC 233.
In the last hearing, my lord, I submitted lot of judgments of Delhi High Court, my lord, of subject matter. In the junior,
In this case, no judgment is required. This will be decided on facts.
my lord, I want to hand over 3 judgments of Delhi High Court on the same junior to be considered for now. If required, my lord.
Keep it. We are not finishing it today. Keep it. 1982 SCC 233. Mr. Mozumdar, I do not think anything will happen. Do you know, Mr. Tas, why this notification was issued? You are relying on that office memorandum. Are you aware?
86, my lord.
96.
96, yes, my lord.
Why it was issued? Do you know the background?
So that it does not cause any hardship, my lord. That is the S.C. Jadhav versus Union of India. Supreme Court decided.
No, not that. There was, prior to this notification 1996, there were similar proposal given for this hardship. That was struck down. It says that when seniority, it is seniority. There cannot be any senior is not acquiring qualification will not do. You cannot amend the criteria. Okay?
Yes.
That went up to the Supreme Court. Supreme Court upheld it and says that you cannot do this. When rule prescribes something, that it should be qualification is like this, it should be like that. However, in the last paragraph, the Supreme Court opined, you are not aware.
I'm not aware, my lord.
You are not aware. Then Supreme Court opined that it is the prerogative of the authority.
Yes.
Isn't it?
Yes.
So, to give away that judgment, to bypass that judgment of the Supreme Court, taking note of the last paragraph, they have issued this office.
Okay.
So therefore, the office memorandum dated 18th of March 1980 is also be relevant, which you are not ready. Neither with the judgment of Prabhadevi, nor with the notification on the basis of which the judgment of Prabhadevi was delivered. This job is to be done by the judge sitting.
No, my lord,
And
I
he will do it.
apologize, my lord.
He will do it. He will
I-
do it.
I could collect some Delhi High Court order, 3 orders, my lord. Last time I handed over to my lord.
We are, until and unless we are satisfied that this is applicable to you, we will not go to that. So therefore, this notification was issued. Your argument should be this notification was issued, Supreme Court has permitted, and this has been issued by the Ministry of Personnel, PG and Pension, which is the controlling department so far relating to the service condition of all the
Central government.
central government employees.
Yes.
Now this has been marked to all the ministries and departments and government of India.
Yes.
And what is the meaning of this probation? Is it meaning only probation for the entry level? Then where is the question of promotion? Can anybody get the promotion during probation? Is it reconcilable? Where is the rule? So Mr. Gupta will show a single rule where there is a scope for promotion during probation at the entry level. This probation, subject to what you argue, shall for all meaning and purport will mean the period which is essential for promotion. In this case, 7 years and superintending engineer. That is essentially will be required. The notification itself is. However, the additional qualification can be relaxed up to half.
Yes.
This is the issue. You interpret as a lawyer, don't go by the statement of the officer. What? Yes, my lord.
Have to,
Who will pay the cost of this 1 hour? Both of you, 10,000 each. For the wasting judicial time.
And I apologize because
Apologize to the others.
my lord, because the last
That's why I have said, first let us understand the facts. When have you been appointed? When have you been promoted as superintendent engineer? What is the qualifying period of the superintendent? This is my case. This is the rule. I have not been given. That's all. 5 minutes this case could have been decided. Your whole case is that I am qualified. I have not been given. You started with amendment. Is a read court having a power to direct to amend? Are we here to legislate?
apologize.
You started with that argument. So why will you not pay 10,000 for wasting judicial time? And this is the last day. Yesterday also same thing happened. Enough is enough. We will not waste time like this. Giving hearing and in fact the Honorable Chief Justice of India has said there should be a limit to oral argument. Give it. Mr. Gupta,
Hmm.
will put you in heavy cost if you people do not come prepared. And when there is a question of interpretation, you are a lawyer, then we'll call your officer. You are a lawyer. When there is a question of interpretation, don't read the statement of your officer. You are the master of law. They are the master of fact. Yes,
I apologize for the inconvenience.
better. You better. Hmm. 26, 26.
My lord, I come from outside, my lord.
We have heard you. Anything to be added? We know your facts. When you were appointed, when you were promoted, when you were posted
My lord,
in
one-
task force. Your case is that in view of the notification, I am entitled.
no, my lord, there is an amendment of the recruitment COPD guidelines also,
mm.
page 46, my
Mm.
lord, which says that if somebody is 7 years service
Mm.
with 1 year in the superintendent engineer gate, where that the junior has been promoted on that ground also.
Mm.
There are two line of submission. My lord. One is that, and another is that amendment of recruitment.
What is the meaning of probation, Gupta? Hmm? Okay, tell your date. Tell your date. Your
Madam-
convenient date.
Yeah. Matter in the 23rd of
Tell your date.
next-
Pick it up. It mo kailangan natin. Tell it. Yes, yes, give that.
yes,
You
my lord,
cannot take-
29th of Feb will be all right, my lord.
Yes, 29th. Possible? Hmm? One. From tomorrow on discount, no adjournment. We'll decide the court. Enough is that. See. Gupta, be
Hmm.
ready with everything.
Hmm.
It's not
Okay.
that this question is not put today, other questions will be put on the next day.
Hmm.
And don't make a statement that I want instruction on law from my client. Then I will not allow you to enter into this. But you are a lawyer.
Keep your breath.
Yes, Mujumdar. What is the issue here?
That it matter
What is important?
that
Okay, I want to know what is what.
we have prepared that chart, we will post ready. Let us qualitative.
Okay, when
Any other convenient paper, we have
Okay.
prepared with.
fully to positive, let I put that be taken up with this method on 29. Okay,
So,
others? All given date? Anybody having an urgency?
14 meter,
Ah,
very long.
19, I don't know, 19. What is the issue here?
But here the promotion, the anticipating the date of promotion. Actually, there was adverse entries in his ACR, which was not communicated. As a result, he was not given promotion in due course, and his junior has bypassed.
Hmm.
Thereafter, he was subsequently on the next grade he was given promotion and he now climbed up to the level of deputy commander.
Hmm.
So his prayer is that his promotion should be anticipated from the date of promotion of his duty. Because uncommitted,
Limited issue.
yes, correct.
When-
Uncommunicated adhered.
When? No, we know it's poor, otherwise will not be possible. When? 5th of March. Okay, anybody? After 4 is good. 15 to eta diba? 17, 18, 20. That. Keep this book.